Writ appeal. Order to be posted in the month of June. I filed an early hearing since the respondent one has filed a contempt petition. Petition is ordered to be petition 2nd April, 2 years before the charge, and file the reply matters. Union of India officers have been newly added as accused matters. A sought for stay of the impugned order, that is land acquisition. There is a dispute with regard to identity of the property itself. The Lordship directed the state government and the respondent one to file the objection through our date is in the month of June, but contempt petition 2/4. I filed an early hearing application yesterday. Informed and served the copy also the early hearing. Any date 27th that contempt they have filed in the 2021. Recently they have added the Union of India officers as accused just 1 month back. 2/4 minutes. Any date before that minutes? Appellate. I've already informed, again I'll inform. Writ appeal. Yes, ma'am. State government and one private party, that's all. Yes.
Cross appeal. Cross appeal.
No.
Yes.
Yeah, cross appeal. Well, a memo for clarification of the court fee. I have to pay the court fee, how much they have to clarify. So that is not comes to.
What do you want?
For the clarification of the court fee, I have to file a cross appeal, Your Honor. Tom appeal. There is a government has filed an appeal and I have to file a cross appeal. This officer will raise to whether it's a court fees comes to more than 1 lakh something. But I have to clarify that there is no any court fees comes, then I have to clarify the court whether I have to.
Objections.
There are objections.
Let's see that.
Yes, please.
According to the registry you can pay, you can still.
That is not comes to the jurisdictions, Your Honor. That is the appeal. That is the cross appeal. It's not come to the court fee. Already I paid in the trial court. Whatever that amount has to be, I have to only. Yes, here also. I will be paid there in the trial court.
Pay here also.
Here also. But I am not taking a relief. I am not seeking. There is some clarification.
There is appeal.
Yes, please.
Right. Keep it back. We go over it.
Yes, please.
Okay. Yes. The intervention.
Please.
Sir, serial number 22, Your Lordship.
Yes, Mr. Gupta. In my case, even after order of this Honorable High Court,
My Lord, even after the order of High Court, this Honorable High Court, the respondents have revised seniority list in violation of the orders. I want to stay. I had filed. Okay.
the allegation.
Yes, my Lord. And my Lord, one more case. So this is casual labor. She has been removed from service after 25 years without any reason. Yes, my Lord, it is a petition. Tribunal rejected my case without conceding my request. Yes, my Lord. Yes, my Lord. Yes, my Lord.
Thank you.
My Lord, serial number 8, my Lord.
Sir.
My Lord, serial number 8. I'm appearing for the appellant in this matter. We have filed one set of memo, my Lord. The matter is posted for office objections. We will file the second set in week's time, my Lord. A date may be granted, my Lord.
Yes, 1 minute. Just 1 minute.
For adjournments, page number 8, serial number 21, page number 9, 22 to 28.
Your Lordship, serial number 22, Your Lordship. I seek a week's accommodation, Your Lordship. And other side has been
Who
informed.
is the other side?
Advocate Shashidhar Belagumba, Your
And
Lordship.
there is an issue of maintainability, ma'am. Here.
Your Lordship.
There is an issue of maintainability. We are putting it to you so that you can answer.
Yes, Your
Okay?
Yes.
The appeal is against an order under order
Interlocutory.
Rule
Yes.
14.
Yes, Your Lordship.
That's not an appealable under order 43. So just check up that.
Yes.
Who you have mentioned, you have told the other side.
I've informed Your Lordship.
Huh?
I've informed the other side, Your
You have
Lordship.
informed. Just say that at the request of counsel for the appellant for an adjournment, stating that she has informed the
opposite, the counsel for the respondents adjourn to.
Even respondent
four.
counsel is present. Interim order may be extended, Your Lordship.
Interim order, if any, be extended.
24-4.
My lord, serial number 26, my lords.
Yes,
Serial number 26, my lord. 1 week of accommodation may be granted, my lords.
6 weeks are granted to file paper books.
I appeal for the respondent in the matter. Last date of hearing, my lords, they have undertaken to deposit certain amount before the trial court. However, they have not done it. Let them be instructed to file deposit amount, my lord.
My lords, in fact, in this case, IRP has been appointed, my lords. We will produce all those documents before this court, my lords, on the next date of hearing without fail.
Okay. Who is instructing you?
My senior, my lord.
No, but is the IRP instructing you?
Please, my lords.
We want that.
No, my lord.
Then who is instructing you? Just wait. We'll call the matter.
Please.
We'll call the matter.
Page number 10, 29 to 34.
Yes, my lord, serial number 23, my lord. Appealing for appellant, my lord.
Which-
Kindly 1 week,
Which time?
20.
time may be.
Which number, ma'am?
Serial number 23, my lord.
20?
3, my lord. Seeking for the
23.
adjournment, my lord. I have informed other side.
Yes, what do you want?
Seeking for the adjournment, my lord.
Why?
Kindly 1 week.
You have not even deposited the amount.
My lord, I have deposited 50% amount, my
You
lord.
have deposited.
Yes, my lord, please.
The learner counsel for the appellant, by stating that the appellant has deposited the 50% of the awarded amount before this court seeks an adjournment. The request is not opposed, adjourn to
30th June.
the registry to give its report on the deposit made.
Page number 10,
Grateful, my lord.
page number 11, 35 to 37. Page number 12, 38 to 42.
Serial number 39, Your Lordship. I seek a week's accommodation in this.
I appeal for the respondent in this matter. I have no objections.
39, just say at the request of counsel for the appellant for an adjournment, which is not opposed, adjourn to.
30th June.
Much obliged.
The 40 million.
Next,
My lord, serial number 37, my
40,
lord.
my lord.
My lord, serial number 37, my lord.
yes,
Date may be fixed to 9th, 10th or 11th of April. The other side also is informed,
Who
my
is the
lord.
other
My
side
lord,
in
I'm for the
this?
respondent.
In all the
Senior
matters?
counsels are going to argue in this matter. I appeal for the respondent in this matter.
Give it in June, at the request of counsel for the appellants. You are for the appellants?
I appear for the respondent in this case. Serial number 37, my lord.
You are for whom?
I'm for R1. R1.
Darwin, there are three people.
BM Alaswamy. I'm appealing for BM Alaswamy. R1. Advocate BM Alaswamy.
Okay, for the appellant, for the respondents, just say respondents. Ujjwal Deep and others.
Which will?
Re-notify on.
30th June.
It's serial number 40, my lord. For the appellants, appellant number 2, my lord, I'm instructed is no more, my lord. I will take the
40.
necessary, 40, my lords.
I'm the respondent.
Second appellant is no more, my lord. I will take necessary steps in this.
The
regard.
learner counsel for the appellant states that the second appellant has expired and he shall take appropriate steps in that regard. Adjourn to.
And stays in operation may kindly be continued.
Who is the other side?
Respondent. No objection.
Respondent, the counsel for the respondent has no objection.
And stay may kindly be continued.
Interim order, if any, to continue.
Obliged.
Hello.
30th June. Serial number, page number 13, 43. Page number 14, 44.
I appeal. Serial number 44, my lord. Seek a week's accommodation, my lord. Other side is in.
I appear for appellants, this matter, appellant.
At the request of counsel for the respondent,
Sole respondent.
respondent adjourn to.
30th June.
Appellant.
Serial number 1, was it? Was it?
has
Well,
come up,
Yes, what are your submission, Mr. Beliapa?
but it has come up for the first time. The Lordship have it day after tomorrow.
Well, the son of the petitioner is missing from 13-3, my lords. And he has criminal antecedents. So there is a doubt whether the police has taken him under custody or some people
You
who have
any
some.
information?
It appears there is a crime registered against him, and in that probably is all the
Has
phone.
Has he been detained then?
No,
If
no, missing. No.
my lords, if that information is
Yes,
got to me, I can be silent because I am the mother of my of the missing
Tomorrow,
person, my lords.
Tomorrow.
So you accept that you didn't get other information, whether he has been detained or not?
No, he is not in the custody of the police.
He is not in the custody.
And my lords, whenever I'm going to the police station, the police is not entertaining me. And if I give a complaint stating that these people have taken my child, they have picked my child from the home, the police is getting them to the police station and taking illegal money and leaving them, my lords. They are not entertaining me, my lords. My child is missing from 13-3, my lords.
What is this, that you have registered? What are the offenses?
No, it appears that the wife has registered a missing complaint on 16/3/2023. Now the mother has come up before the honorable court.
Wife has
Saying-
also lodged.
Lords,
Wife has also lodged a missing complaint.
yes, as on 16/3/2023.
Hmm.
Now the mother would allege that she was also beaten up. There is no complaint with regard to that. That's what he says, Lord. We will ascertain all these facts.
Well, that's
Because it is
whenever
very-
I go to the police station, the police is making a joke of me and not taking my grievances.
Well,
And the
if
mother is, and the petitioner is present before this honorable court, my lords.
Issue notice. Mr. Beliapa accept notice for respondent number 1 to 6. He seeks and is allowed 2 days time to take instructions, re-notify day after tomorrow.
Because he says the custody is with respondent 7 to 12, not with the police.
So I can read the definition of if my lord permits me,
No.
I can read the definition. My lords,
Just
the-
1 minute, please. They have a custody.
No, that's what
If-
he's
yes.
alleging.
What he says is illegal custody.
Yes, yes.
He-
writ of habeas corpus, there's a clear definition. It can be a private custody
Of
or
course, without a doubt.
Objections be removed before the next date of hearing.
26/3.
obliged.
We are just issue notice to 1 to 6.
Yes, my lords.
Serial number 2, Shri Matapati.
Yes,
Senior is appearing through VC. Seek for a passover.
Appearing for the
so it's
state. my lord.
difficult to. Who is the counsel for appellant?
I'm appellant.
Yes, tell us.
Senior counsel is appearing through VC, my lord. Some.
Did we hear this matter?
Mr. Nawadgi is
Troubling nowadays. Troubling nowadays.
Hmm?
Troubling nowadays.
problem.
Just say Passover.
Please.
Serial number 3,
Yes.
Yes. The ascertain, my lord, that it appears that it is at the behest of the boy himself. This petition is before the court, so he is willing to take care of
Where are the parents?
parent
Serial number 4, Srimati Shilpa Shah.
Here for the appellant. My lord, respondent number 1 is reported is dead. So my lord, we have filed now application to bring LRs on record. My lord, notice maybe.
Just say that issue notice on these applications to the proposed LRs of respondent of respondent number 1. That's right?
Yes.
LRs of respondent
Yes,
number 1.
yes, my lord, yes, my lord. So there are 3 LRs.
So we issuing notice on that.
Yes, yes,
Next.
17,
obliged.
serial number 5, Shri Partha Sarathi.
Respondent number 2, appearing for petitioner, my lords. Senior is at the trial court, my lords. It may be passed over, my lords. Senior is at the trial court. The appeal may not be maintainable.
Where is the application?
Madam, application. Number 120.
Have you removed the objections?
My lords, I've been instructed to pass over, my lords. My senior is on the way, my lords.
Let's see the objections removed.
9.
You remove the objections first, then only we'll consider this application.
Obliged, my lords.
We just say that this is an application 1 of 24 for recalling of order dated. Is it 21/6 or 22/6? 22/6/2024. We note that there are 9 objections notified by the registry in the writ appeal. So before we consider the application, the objections be clear within 6 weeks based on.
17,
Obliged.
serial number 6, Shri Hegde.
No, I'll do today only needful data.
What are you saying?
Today I'll pay the processing fee. Yeah.
Let fresh notice be issued to R1 and R2.
17, serial number 7, Shri V.S. Nayak.
Yes.
Sir, I issued notice of retirement to my client.
Right.
Lord,
I will undertake to file NOC Okalat, my lord, sir.
You are ready?
No, short accommodation.
But the difficulty what?
Get your memo.
I'm not.
We'll hear
received-
it.
yes. I'm not received NOC Okalat. I mean, today they will,
Doesn't make any difference. We will record it.
no, not, I'm not having with file.
Give the file. to
Today I
him.
get the
I'll
information,
hand
that's
over the
that
file
I don't.
by today evening, I'll
One
hand
week.
over the file.
Why don't you argue? Re-notify tomorrow.
Next week. that's fine.
Lord, the difficulty is,
Next
my lord's
week, my lords.
pension is not settled. My
No, my lord.
orders come
We are
from
ready to
officials.
settlement, my lords. He is also present before the commissioner for.
We'll just
settlement.
pass over. Please get it.
No, my
Memo,
lord.
everything.
Have not received any file, my lord. I'm not-
We don't
Next week,
understand
my lords.
why on the last
Kindly have
day.
it on next week, my lords.
When did you file your retirement?
Tomorrow I'll be filing it because there was no
You have
response.
not filed it?
I have not filed.
We will hear you.
I'm sorry, my lord, today. Since
We will hear you. You are on record technically.
at least one day, my lord, today, because my lord, because my lender friend is also
Next
going to
week.
appear for the.
Last occasion, my lord's time. was
Just
not
at the
on
request of counsel, whose request shall we note?
Yes, my not my request. I'm yes.
At the request of Mr. V.S. Naik, we notify all.
Next week.
Just give it in June. No June, just give it in April.
It's more than 2 years, my lord, since my pension is. settled.
Eight.
It's all right, Mr. Srikanth. Let's see.
8-4, sir.
Please.
Give the date.
8/4. Serial number 8, Srimati Ashwini.
My lord, appearing for the appellants in the matter, my lord.
Yes.
My lord, advocate and record is traveling currently, my lord. A week's time may be granted, my lord. We'll address our arguments.
At the request of counsel for
Was
the
heard.
appellant, adjourn to.
Much obliged, my lords.
Happen, ma'am.
Previously, my lords had heard this matter.
I know, what is the date we have given? Just give a short date.
9/4. Madam, 9/4.
Much obliged, my lords.
Serial number 9, Hemant Reddy.
Have you filed the translations?
Please, my lord. I have filed the memo along with which I have produced the award passed by the SLAO, my lord, that is the competent authority.
Just pass over them.
Please. ma'am.
Fix.
Serial number 10, Sri Ranganath Police.
For the respondents.
Respondent to file a reply and they have filed the reply, my lord, and I was asked to file a rejoinder in the form of affidavit. I am filing it, my lord. Copy. In the very reply now filed also, they have stated that the second ACP granted to me has been treated as first ACP. For that, there is no problem at all. Up to that, problem is solved, my lord. Thereafter, if the first ACP granted as per their own reply is that after merging the above two pay scale, second ACP was granted to me in 6,000 so pay scale with the GP portion, which was considered as first ACP. So once it is first ACP, on completion of 24 years, which comes within the range of first OM of 1999, I become eligible for second ACP. From 4,600 in the hierarchy, the next case is 5,400. That is what.
What about 4,800?
No, 5,400. Kindly see this, my lord. Hierarchy of ports. I have kindly see page number.
Did you get 4,800?
4,800, no, 4,600 they have given, not 4,800. They have given 4,600. And as per the hierarchy, 4,600 next hierarchy is your last hierarchy in the application. I have extracted page number 25 of the writ petition.
Hierarchy in the promotion post or hierarchy in the scale?
Hierarchy. 4,600 was the last. Thereafter, next is 5,400. And as per the OM, now come to the OM, how it should be done. That is that page number, annexure A13, the OM under which it has to be regulated. Your lordship will kindly see page number 85. Page number 85, para 9 of the scheme. That is 1905-2009 scheme. Page number 85, para 9. Any interpretation, clarification of doubt as to the scope of meaning of provisions of MACP shall be given to the department and training process. The scheme would be operational from 1/9/2008. In other words, financial upgradation as per the provisions of earlier ACP scheme would be granted and 31/8 to the up to 31/8. So I become eligible before that. Then come to next page, 85. 85, para 2. MACPS envisages merely placement in the immediate next higher grade pay in hierarchy.
This has been interpreted, Mr. Joyce. These all have been interpreted by the Supreme Court. Let's not go by this. Let's see what is the law.
In fact, for all others, it has been
Now,
granted.
where do you say next this thing?
That page 94. Page 94. There is a clarification issued by the DOPT. Kindly come to page number 94. Page number 94. Individual cases of such cases have been examined. Page number 94 is a clarification issued by the DOPT on 9 September 2010. The relevant page at page number 94, item number 3, point of doubt. How will the benefits of ACP granted if due between from 1/1/2006 to 31/8/2008? The new MACP.
Where have you read? You just read next higher grade pay. Where is that?
However, the pay structure has been changed from 1/1/2006. Therefore, previous ACPS would be applicable in the new pay structure adopted on 1/1/2006. Para 6.1 of annexure 1 of the MACP is only for exercising the option for coming over to the revised pay structure and not for granting benefits.
Where are the recruitment rules?
This is the hierarchy of post.
We want the recruitment rules. We want the recruitment rules. Show us the hierarchy.
This is fine.
This is the office of the Registrar General. Where are you working?
Same.
But question is not that. Question is whether the earlier promotions you are appointed in which grade? Which post?
He was initially appointed as a statistical assistant on 6/11/1982.
Then
First ACP was granted on 30/12/1999, the first ACP. That order I had produced dated now because the scheme has come into, though it has first ACP is from 12 years, but scheme came in 99, therefore the earliest date that could be given was 9/8/99. That is the first order at annexure A1, under which the first ACP was granted. And it is said the order applicant's name is at serial number 1. Well, strangely, kindly for a comparative study, come to page number 36 of the same order granting first ACP. There are what are called as data entry operators grade B, which is of the same scale of 5,800. Kindly come to page number 36. All these about 30 persons who are all data entry operators who are also granted first ACP in the 5,000, 8,000 like the applicant. Thereafter, they were also granted second ACP in 2006. That order came to be corrected by applying the said principle. That order, that order, the government, the respondents themselves have produced that order where they changed 4,600, they have changed it to 5,400. Order. Page number 121, annexure A16. Identical cases where along with me the data entry operators were given initially first ACP, but thereafter second ACP they were granted in 4,600 like me, but that order they found as per the OM annexure A16 page 121. Just reading of that consequent upon the Ministry's Personal Public Grievance and Pension Department OM dated 9/8/99, the clarification issued on 9/3/2015 by the Ministry of Finance and 8/4/20, recommendations of Department Steering Committee, the grant of financial upgradation under the ATP scheme.
What was the merger? What was the merger scale?
5,500.
6,000?
500.
6,500 to?
9,000. 5,500, 9,000.
You file your rejoinder?
I have filed rejoinder with the same point, same thing I have stated, that admitted fact is that so far as the first ACP which was granted in 1999.
But your claim before the tribunal was your first ACP should be 7450.
Yes, in the reply statement they did so, but factually there was no the orders impugned were not corrected. In the reply they admitted that second ACP is treated as first ACP. Consequential order to that effect was not passed. If such an order is passed, next order automatically as per the 99 OM.
What was the second ACP?
Second ACP completing of 24 years under the old scheme of 99.
But that was in the 6,500.
Yes.
But you are seeking first ACP in 7450. The first ACP was 5,500, 9,000. Then you got it in 6,500, 10,500. Then what was the merge scale on 1/1/2006?
5,500, 9,000.
5,500.
4,500 - 7,000 and 5,000, 8,000.
When grade 1, grade 2
Yes.
has been merged on 1/1/2006, how much you got?
Okay, let me tell you.
First it gets 5,000, my lord, 5,500 monthly, my lord. It will become 4,200 grade pay, my lord. Then there was the calculation as the first ACP.
Have you filed your rejoinder?
Yes.
Yes, my lord, I have filed it. Today I filed it. The Lordship may kindly take it, sir. Read it.
Just say rejoinder has been filed, renote, the same is taken on record, list the writ petition for hearing on. Just give this to them.
Ten six. Serial number 11, Shri Murugesh Charity. 11.
Yes.
IA number 1 of 11.1, my lord, I appear for the appellant.
11.3, my lord, I appear for the appellant. And in 11, my lord, I appear for the proposed respondent.
It's appear for respondents in 11, 11.2 and 11.3. Well, friends appears in 11.1. We had filed IAS number 1 of 2025. In the first of the matters filed by LRs of R2. In the other matters, LRs of R1, my lords. We have ourselves filed an application to come on record and prosecute the matter.
10.3.
No, but this R1 is same as R2.
Please, my lord, Uma Shankar, same person.
And in
Original petition.
We have no
objection for the allowing the LRF.
Just say IA1.
My lords,
in 11.3, my lord.
I appear for respondent number 6A in 11.1 and appellant in 11.2, my lords.
826.
No, but you appear in which respondent in 11.1?
11.6A, my lords, 6A.
Okay, let's just wait. Just say that 1 of 25 in RA, WA 582 of 21. This is an application for bringing the LRs of respondent number 2 on record. The learned counsel for the party appearing for the other parties have no objection if the application is allowed. What are the names of the LRs?
Sumangala, the wife. Yes, Sumangali.
The following LRs of LR of R2 as Sri S.
Sumangali, wife, and 2 children.
Sumangali, Sharat Kumar and Pradeep Kumar be brought as respondent 2A, 2B, 2C respectively. Okay. The application is disposed of. Similarly, IA 1 of 25 in WA 559 of 2021 for bringing the LRs of R1 Uma Shankar.
Yes.
Has been filed. Full stop. This respondent is the same respondent who is respondent number 2 in WA 582 of 21. Full stop. Having allowed the allow the LRs of Uma Shankar, late Uma Shankar to be brought on record. We allow this application also, the aforesaid the aforesaid LRs of respondent number 1 be brought on record. Accordingly, the necessary amended memo of parties and amendment to the memo be carried out by the counsel for the respondent 1 for the who appears for the LRs
I appear, my lords, but amendment has to be carried out with the appellant.
by the appellant. Just say that the so and so accept notice for the LRs of respondent number 2 in WA 582 and 1 in 559.
My lords, I
By the counsel for the appellant, just say that in the counsel for the appellant in the aforesaid appeals.
11.3 also, my lord, they have filed the application, but it is not put up, it seems. Similar.
We'll look into it.
It's same, my lords.
Which one?
11.3.
Is also one.
He is also one. Uma Shankar.
Same person, it is filed on the
Say
same.
that learner counsel will allow this also.
Please.
The learner counsel for late, who you appear for whom? Who is the counsel for one?
It's 11, 11.2 and 11.3, Pawan Kumar MN. That
Mr.
is me.
Pawan Kumar MN.
11.1 is Omkar.
lords,
Pawan Kumar MN, who appeared for late Uma Shankar, states though he has not filed any application, the LRs of late Uma Shankar being
Applications filed by me. Before I reported and I filed application to come on record. That was on the last year.
say that though the application has been filed, the same has not come on record. He requests that as the prayer is similar to the prayer as made in WA 58221 and 55921 on his oral request. The LRs of the aforesaid LRs of Uma Shankar be brought on record. The counsels appearing for the other parties have no objection if the aforesaid LRs are brought on record. Accordingly, it is ordered accordingly. Let necessary corrections be made in the amended memo in the memo of parties, and amended memo of parties be filed by the appellant in this appeal. That's all.
my lords,
He is also 11.3 is also same.
11.3, 11.2, 11.1 is R1, same person. In the main matter, 11 is R2.
Same order in 826 of 23 also.
11.1, I appear for the legal representatives of respondent number 1. I have furnished my name,
What is your good name?
Omkar Kambiman.
Mr. Omkar so-and-so accept notice for the LRs of respondent number 2 in WA 581. 582. That's
559.
559, respondent number 1.
559. You appear in 11?
11, 11.2 and 11.3.
11, 11.2 and 11.3. Ma'am, just note it down. Huh? You will accept notice for the
Please, I've already filed
LRs.
wakalat.
LRs. Okay. Now there is one R13, proposed R13. Who has filed it?
Proposed R13 is filed by the previous advocate of the same party. Now that 11.3 is filed by the same person as separate petition, my lords. He first sought to implead himself in my petition, though he was not a party in the writ petition. In appeal, he came on record. Now he has sought leave to file an appeal and filed a separate appeal. So that will technically become infructuous, my lords. But on the last day of hearing, I submitted that let the application not be disposed of, because I want to argue on certain documents filed by him in the IA and not in the.
Okay. List the appeal.
My lords.
We will do that. Just say let the appeals on.
Lords, if I may request very short date, my lords, because writ petition of the year 2011.
I know we will have it. We'll have it in June only, not before that. We have a lot of
My lords, in 11.2, an application has been filed for bringing the LRs of R1. That may be allowed, you know.
We have allowed it, ma'am.
Please, please, please.
Copies with, sir.
They must be appearing, anyone appearing for them.
I shall furnish the copies.
Just give it a copy to him. Take
Please,
it from
I
Mr. Charadi, just take it, just give it to him.
I shall.
Just list the appeals on
Short date.
June.
Here it was coming up for final hearing, earlier using application.
Not possible, April is not possible. Next.
From 2021,
there is an interim order of status quo to be maintained by the parties. That may kindly be extended.
Yes, sure. Yes, sir.
Lord, I had to bring your Lord's time notice. Lord, every date of hearing was being extended. Last date of hearing, Lord, when the matter was put, the applications were not served, Lord. The LR applications were not served. For that reason, it was adjourned. I made a request, Lord, that the interim order could be extended, Lord. Somehow, Lord, I found that later when the interim order was.
Just say that interim order, if any. We will say wherever there is an interim order. Interim order, if any, to just say interim order, if any, to continue. Interim order, if any, to continue.
Last date of hearing, Lord, it was not extended. That is the reason, Lord, I thought, Lord, I think your Lordship kindly.
What do you say?
Please.
Wherever. No, we'll report, we'll last.
Earlier granted me.
No, 23, 2024, 24. Interim order, if any, shall continue to operate till the next date of hearing. We have said so. Thank you. This is a common order. Common order.
Date. June. June.
16-6. Serial number 12 is Suresh.
Please, Your Lordship, appear for respondent number 1. Agreed to settle the offer, whatever. After the session, filing the state attorney conclude. I say that my lord can adjourn the matter. I appear for respondent number 1. I have no such instruction. Yeah, the department has, I'm for the appellate. I've been approaching the department and the department has given us assurances that they settle conclusion upon the conclusion of the session. In fact, they filed an application to delete me as a party. Now, I'm the respondent before the arbitrator, before section 34 proceedings, earlier round of 37 before this honorable court, again back to 34, again this is the second round of 37, I'm the respondent. Now, they have filed an application to delete me, but I have not received a copy. But in the, that is IA number 2. And I've also paid the arbitration award amount with interest. I don't know how they will reconcile with that if I am deleted. They would want to refund.
So what
that
do you
amount.
want?
I will serve a copy. In the event that they settle the matter, all of this will go with.
So what do you want? Are you settling the matter?
No, 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 I have no such instruction. In fact, this has been the story that has been told for the last 10 years. That there is a settlement, there is a settlement. And multiple number of letters are brought forth before this honorable court, where they issue letters or request letters before some minister, some secretariat, and they get a note on those letters. And they produce those letters before this honorable court saying that there is a settlement, there is a settlement.
We say at the request of counsel for the appellant adjourned to.
Yes, yes, sir. And they may be directed to serve a copy of IA-2.
Let the copy of the IA number
2
of
24.
2 of 24 be served on the counsel for the respondent.
18-6.
2 of 24. 22. Will be 22. 2 of 22.
Serial number 13.
That's it.
Amendment.
Say, short question for Lordship's consideration is, the learned arbitrator has awarded early completion incentive, though it does not form part of the agreement terms, man. That's the only short point, matters which we have canvassed before the arbitrator. He has not looked into. Kindly turn to the appeal memorandum, page number 62, minutes. Paragraph 16.
16.
Paragraph 16.
How much he has granted because of that?
Around 40.
% of the contract value, in and around 2 crores 80 lakhs. 6% of the contract value.
Just show us.
First, kindly turn to page number 62, Lordship's paragraph 16. Around 10, 11 lines in that paragraph, minutes. 12 of the GCC is there. After he submits that the incentive bonus clause was not made a part of the tender notice and was not uploaded on the website, and hence the claim is liable to be rejected. He submits as clause 12.6, the decision of the chief engineer in respect of incentive bonus shall be final and binding on the contractor. In the first portion itself, we have produced the clause 12 in the very appeal memorandum itself, my lords. May I request you, lords, to turn to,
Where are you reading?
my lords, page number 62, paragraph number 16, my lords. That is a award,
It's not 62, it is 59. It is
appeal
59.
memorandum, my lords.
Sir, it is 59.
Appeal memorandum,
Award.
award,
Award page number 8. Na?
8.
Correct. That is 59. You know.
Paragraph 16, your lords. That may I read, my lords, 3-4 lines down then. The matters, may I request, he relies on clause 63 of the GCC, which is marked as exhibit R2. The matters which are referred to in clause 63 are to be termed as accepted matters, and they shall stand specifically excluded from the purview of the arbitration clause. He submits that clause 43.2 of the GCC relates to issuance of no claim certificate, and that being an accepted matter, the question of the claimant invoking clause 12 of the GCC does not arise. According to him, there is no arbitral dispute exists between the parties. He further commented on invoking clause 12 of the GCC. He submits that the incentive bonus clause was not made a part of the tender notice and was not uploaded on the website, and hence the claim is liable to be rejected. The specific case of the appellant is, my lords, clause 12, which deals with the payment of early completion incentive, was not a part of the agreement. And the learned arbitrator, my lords, discusses the very point at paragraph number 33 minutes. The relevant clause is extracted at page number 15, paragraph 30.
What is the finding?
Finding minutes at paragraph number 33 and 33 and 34 minutes. Award. May I read, your lordships? If the 33 minutes, if the consideration of the learned counsel for the respondent is to be looked into with regard to 12.6 is concerned, it would deal with the decision of the chief engineer in respect of the incentive bonus. The decision of the chief engineer shall be final and the binding on the contractor. In this regard, the learned counsel for the respondent has pressed into service exhibit R4. A perusal of exhibit R4 clearly indicates that in the first instance, the claim for incentive bonus was accepted by the respondent, but however, the same was denied on the ground that since the payment of incentive bonus was neither uploaded in the tender notification nor discussed in the TCP, a perusal of clause 12.1 clearly indicates that the incentive bonus is payable for early completion of the work were specifically provided in the tender notice, tender conditions. Incentive bonus is payable for earlier completion of the work in contract provided in detail notice tender conditions uploaded in the website by the respondents. Thus, the perusal of the said condition would clearly indicate that it is a part of the tender condition and it cannot be considered as a general condition in the tender and hence cannot be invoked. I am of firm view that the question of denying the incentive bonus to the claimant in the circumstance would not arise. The only reason assigned by the chief engineer is that it is not the part of the tender notice inviting the tender, and the applicability of clause 12 would not arise. It is like begging the question, if really the respondents were not keen on applying clause 12 of GCC, likewise, clause 12.6 will also not be applicable, which is part of GCC. Thus, the question of 12.6 being applicable would not arise, and to my mind, the reason assigned by the chief engineer for denying the incentive bonus to the claimant cannot be sustained. If the reason given by the chief engineer is not accepted, the question of denying incentive bonus to the claimant does not arise. The question will be, what will be the incentive bonus the claimant will be entitled? Now he has made that 6% and our first condition itself that it does not form part of the tender condition itself.
Where is that? Just show us.
Class previous page, Manars, previous page, the clause has been extracted by the very same arbitrator himself. Matters it says that form part of paragraph 30 in page 15, 12, incentive bonus payment for early completion of work for cases pertaining to doubling traffic facility throughout enhancement work or any other special. 12.1. Incentive bonus is payable for early completion of the work in contracts where specifically provided in the detailed tender notice, tender conditions uploaded in website.
No, but in any case, incentive bonus is available.
It's available, but only when
Only when?
only when it is uploaded along with the tender notice. Otherwise, it not.
But this was not uploaded.
Not uploaded. That's what our specific contention matters. This class 12.1 also says
How does the arbitrator deals with this?
how he does not deal with that point itself.
My
Can you
lordship,
look at it? Man?
My lordship, without there being a tender notice, but there being a clause in the tender notice, it would not have been reflected in the contract agreement. If the tender conditions does not have this clause in the tender conditions uploaded in the website, subsequently it should not have been reflected in the agreement. Whether they are denying that it is a part of the agreement or not. This is a part of the agreement, my lord. This clause 12 is part of the agreement.
And this was there, incentive bonus is payable.
Uploaded in the website without uploading it to the website. It cannot become part and parcel of the agreement. This is a government contract. And the tender conditions uploaded in the website, my lordship, let them furnish. That is available in the tender conditions uploaded in the website. Based on that, we have quoted the tender. Let them furnish that. What has been uploaded in the website. It is part and parcel of the tender conditions uploaded in the website, my lord. That is what the arbitrator's finding is. If it is not part of the tender conditions, it would not be part of the contract agreement also.
But tell us one thing, was it part of the GCC? Was it part of the GCC?
Maharaj, that's not the case, Maharaj.
Conditions of the contract.
Conditions of contract is applicable to various conditions, Maharaj. Whenever such a thing is to be given, there are certain terms and conditions. One of the condition is that it should be uploaded along with the tender, saying that this work entitles for the early completion incentive, Maharaj. That is not there. In our case, is very specific, Maharaj. That's what we have discussed. And it, class 12 is there.
Now this tender condition was not uploaded.
Not uploaded with regard to this work is concerned, Maharaj. That's what we have been telling.
Could they prove it?
No, let them furnish the uploaded tender conditions before this.
He also knows that
they are
he
relying upon
himself
that.
is a
They have to
participant. He knows
No,
it.
but tender condition, no, but where is the GCC?
No, GCC, this is not part of GCC, my lord.
This is part of what? Because
Contract agreement. This is part of contract agreement.
no, right. See at the top, clause 12 of the GCC.
GCC.
Exhibit R2.
Yes.
It says at the top. So where is the GCC? Now GCC has this clause.
It has the clause, my.
It has the clause. Now, according to him.
Yes.
You are putting a further, GCC has the clause, but that clause must be uploaded on the
Along
website.
with the website. Then, and there are certain qualifications to avail that also. First condition, he has to threshold, he has to cross minutes. First thing is that condition is there, whether it applies to him or not. That is notified in the when tender is uploaded. In our case, it has not been. This does not form part of that agreement itself. Notification. That's what exactly the 12.1 says.
How would we come to know whether this was uploaded on the
The
website? or
tender
not?
documents which have been uploaded, he himself has downloaded and he himself has.
Where is that uploaded?
That's full documents is.
Where is that uploaded? We will see it.
Uploaded, we don't have, my lord. So it is very long, old tender.
We don't
And
know.
it is in the website only. It is
see-
online tender, my lord.
See, 12.1 would be
12.1
applicable if it is uploaded on the website.
It is uploaded, my lord.
How do we get that?
But I have to verify the website, my lord.
That's what, and where is the case setup? It was not uploaded before the,
Yes, Manar, this is.
where is the case setup?
It is there, Manar, in the page number 34, paragraph 34 itself. 33 and 34, the learned arbitrator discusses the contention what we have raised, Manars. In this regard, learned counsel for the respondent has presented it so and so. Then the same was declined on the ground that since the payment of incentive bonus was neither uploaded in the tender notification nor discussed in the TCP. The perusal of clause 12.1 clearly indicates.
Where is your, this thing, statement of defense?
But statement, this is extraction from statement of defense only.
We want to know, have you said so? It was not uploaded on the website.
This extraction of the minutes, I will just place it on record.
It will be there on the tender file, my lords. It is maintained by the respondents. The tender conditions uploaded in the website will be there in the tender file maintained by the respondents, my lords.
I can produce that document itself. Minutes. There's no. Yes, Manoj, the trial court records are not here. Whatever placed
See,
before
we
the.
want to see that.
My lords,
Then I will
Where
place
is
it
your
on.
statement of defense?
I will place it on record with the claim statement.
my lords.
That's the only question which is there.
35, the findings of the arbitrator. Para 35, my lords. At award page number 18, fourth line, my lords. Fourth line. Award page number 18, fourth line, para 35. It is a contract signed by both the parties, and the said contract is binding on both the parties. The respondent has failed to prove that the clause 12 is not binding on the parties. Tender conditions were uploaded on the website. The respondent has not produced tender conditions to show that the claimant is not entitled to bonus. The arbitrator also asked this question, my lords. It is in their custody. They have not produced.
Don't think.
What do you want?
I place it on record the objections as well as the documents which have been uploaded along with.
Just say that at the request of Mr. Kumar to produce the statement of defense as filed before the learned arbitrator, re-notify him. June, man.
17.6.
Appellate.
14. Number 14.
Yes, Lord, serial number 14. Lord, this is the allotment of a VDA site. Initially, Lord, the site had wrong measurements. And because of those wrong measurements, I was a successful bidder in the tender. Because of the wrong measurements, Lord, I asked them to
Mr.
set
Reddy,
it right.
we hope you have been briefed about the last date
Yes,
of
yes,
hearing.
yes, Lord.
Now, what do you have to say? We are only on that, Mr. Reddy.
Yes. Lord, what I wanted to just bear upon your lordships is one issue.
Yes.
That but for the fact that they said that the measurements were larger than the original dimension, it was they who said that it was larger. That was what prompted me, triggered me to say that if it is larger, it will be difficult for me. Then, Lord, they come back and say it is the same measurement.
Yeah. Where is the
After proper
representation?
consideration and after properly measuring the place. That is why, my Lord, this discrepancy occurred.
It's all right,
But can I
Mr.
request-
Reddy. Your whole claim was only for that. You see
Yes,
the
correct.
representation
Yes.
connection.
But I said, so long as the measurements are appropriate and precise as per the tender notification, where it was put up for auction, I'm ready.
Yes. No, I
But
don't
they
think, Mr.
said-
Reddy.
They said it was larger. And
It's
then
all
they
right.
came back, they measured and came back and said that when they said it was larger, I said it was difficult.
Yes.
And I asked for return. But Lord, thereafterwards, they measured again, the engineering department. And they said the measurements are correct.
That's
That
right.
was when I was ready.
That's right.
So, Lord, what prompted me to say that I'm not willing to take it was that because they reported it was larger than the usual dimension. That was the issue, Lord.
Yes.
Because of that, because of their representations, I had to write it. And that representation was not proper. They were the ones who did not appropriately
Yes.
bring out the exact measurement.
Yes.
Now, Lord, when measurements then were prescribed to be correct, that's when I said that I'm willing to buy it. That's the short issue, Lord.
And we have put it to the council, how much cost? See, the whole case has been for the refund.
Yes. No, we had asked for the
And
allotment also.
And the court has accepted. Now the plea is being taken, was taken on the last date. I have
Yes.
made these number of prayers, the learner single judge has not considered.
Correct. Lord, what we said was without prejudice to the return of money,
Where does it
I
say?
requested
How can we make out that without prejudice?
in the prayer, Lord.
Not in the
Kindly
prayer.
see that.
You show it from the impugned order.
impugned order, the judge may not have noted it. That's the issue, Lord. The judge may not have noted it, but we sought, our original prayer was for the allotment.
And Annexure C, Annexure D.
Annexure
37,
C,
page 37.
yes, Lord.
And read that this is the first representation you have made.
Correct,
When there was a
correct, correct.
discrepancy in the size.
Yes, 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 yes. Lord, because they said that it is larger in dimension. Original dimension was 95.16 square meters. Because they said it is larger in dimension, that's when we said that it's difficult.
Yes.
And afterwards they came back and said, no, upon measurement, we find it is correct. Then I
Yes.
stood, Lord, so far as the original dimension of auction and the price is concerned, I stood committed.
So like Mr. Reddy, not in these facts.
It was they who created the distortion.
See, now the whole relief, since only that the relief has been paid, now sought to be claimed. What was your claim was only for the refund and which has been given.
But in the prior column, what we first sought initially was kindly allot the site because I am prepared for the original dimension. The trigger, Lord, was why we were misled was, or we could not place our exact prayer before them was because they said it is larger than the original dimension. It is they who have to answer, Lord, why they said it is larger, though it had the original dimension. That was the
page 17,
difficulty.
page 16, 17, paragraph 2 of
Yes.
the impugned order.
Yes.
Now, read the third line from the bottom, paragraph 2. Counsel further argued that her client known a larger dimension, she would not have staked her claim in the auction at all, and therefore she has withdrawn her bid and sought for the refund of the earnest money deposit. This request having been denied, a direction is to be issued to the BDA for refunding the said amount with interest RUC. That's the only submission which has been agreed to. Yes.
No, Lord.
Okay.
On that, Lord, on that, actually, our actual prayer was that we should be allotted the site because
It so happens
we never forsake.
It's
We
happened you
never
claim
forfeited the prayer.
It happens you claim 4 prayers, 5 prayers, but ultimately what you press is only this, what you have seen in the order. Not in these facts, Mr. Reddy.
We have not forfeited our claim on the thing. The pleadings disclose clearly that we have not forfeited.
Yeah. Thank you. Just say this, the challenge in this appeal is to an order dated 3rd January 2023. Passed in writ petition number 36431/2014, whereby the learned single judge has allowed the writ petition by stating at page 19. It started in the above circumstances as under the submission of Mr. Vivek Reddy and a senior counsel for the appellant is that the petitioner had made the following prayers which have not been considered by the learned single judge. We are unable to accept the said plea of Mr. Reddy for the simple reason that the only prayer pressed by the appellant before the learned single judge, as can be seen from paragraph 2 of the impugned order, is for the refund of the amount deposited at the time of e-auction. The said paragraph reads as under. From the above, it is clear that the submission made is that a direction be issued to the BDA for refunding the said amount with interest. In fact, we find that this plea before the learned single judge is in accordance with the representation made by the appellant at the first instance to the Commissioner BDA on 26 February 2014, wherein she has stated that she would like to withdraw from bidding. What is that? Based or barred? Barred. Barred on technical aspect is due to higher dimension and request to refund the initial EMD amount of rupees 4 lakhs. If that be so, comma, the petition having been pressed for the said prayer and the learner single judge having been granted, it's too late in the day for the appellant to contend that the appellant having made other prayers in the writ petition, the same should have also been considered by the learned single judge. We do not find any reason to interfere with the impugned order in the facts. Full stop. Yes. What about cost?
Entrepreneur.
No, you will not say anything.
Putting
Let us
her
hear
thing.
from the counsel who was there on the last day. Young man.
Only one indulgence.
Her money is caught blood with the VDA.
Okay.
Not my fault on any partner.
Pardon?
It was VDA fault. I've been running around and I'm ready and willing for this site for past 14 years.
Okay. Dismiss. Next.
Please, blood.
15, serial number 15.
Appeal for appellant. Permit to file a statement of objection to the
Yes.
application of interim order.
Where they served a copy to Ms. Malot's.
We'll admit this. We'll admit this. We'll just say admit paper books be filed within 6 weeks. TCR with acquisition.
One seven.
Also permit to file objection to the vacating of interim.
You have filed you're filing?
Yes.
Just say that. Give a copy. Please say that the counsel for the appellants states that the objections to the IA 1/24 filed by the respondents for vacation of the interim order shall be filed during the course of the day. A copy thereof has been given to the counsel for the respondent. We deem it appropriate to let the paper books be filed within 6 weeks. Just say that.
Please.
TCR be requisitioned before the next date of
Will extend the interim order.
interim order, if any, to continue. Have come, don't say TCR, only paper books.
16. Should we hold on? 16.
Appearing for the government, my lord, there's a government appeal also in this. At 16.1, we have filed our LR application dated 5/2/25, my lord. There's an office objection that it hasn't been served in the other councils. I'll have that served. The LR application dated 5/2/25, my lord.
Who has expired, ma'am?
That is respondent number 3, my lord, and their children are being brought on record.
Who appears for R3?
I represent not the disease. I was representing disease R3.
You have instructions?
Yes, I have instructions.
So has she expired, he or she?
That's, I have received the copy of the application. That's the application filed by the government. That's the applications could be ordered. I may permitted to enter appearance on behalf of the legal representative.
We'll allow it.
Yes.
I have furnished the death certificate also.
previous date of hearing, your lordship, so
A similar application has been allowed in the connected matter.
Which is that connected?
That is this matter 814 of 23. The order.
Acha,
dated-
okay, this is now in 1559,
Yes,
this application,
yes.
okay.
Similar order was on 8/8/24, wherein the.
Just say that, huh, we just say this. 1 of 25, no? Seeking, setting aside, this is for condonation of delay in setting aside the abatement. Bringing the LRs of deceased R3 on record. The learned counsel for the appellant states that a similar application has been allowed in WA 814 of 2023. Full stop. Mr. Vivekanand appearing for, you appear for 3 also.
earlier not 5. Before the learned single judge, I have appeared for
So
respondent.
you will state that he shall appear for respondent number 3 as well.
Yes.
Full stop. He states that he has no objection if the application is allowed. Accordingly, the abatement is set aside. The LRs of respondent number 3 being, who are the LRs, ma'am?
The children, my lord, at,
Wife and children.
Being
Is
Srimati Vijay Kumari, Sri Vijay Manjunath N, then Srimati Jayalakshmi N, then Srimati Aruna Kumari. The LRs of respondent number 3 are brought on record. Amended memo of parties be filed necessary and also necessary correction will be made in the memo of parties. Application is disposed of.
my lord, I have also filed a amendment memorandum. saying
For?
that For, after bringing the LRs on record, I have also filed the memorandum of amended memorandum. If that also may be allowed, is my humble request.
Memorandum you have filed?
Yes, amended memorandum
No, where is that?
of that is also dated 5/2, my lord.
What is 5/2?
It is received on 6/2/2025.
Yes. I must say, this is how it should be done. Your application should have amended memo of parties. If it is allowed, it will be taken on record. If it is not allowed, it is discarded. That's how it should be done. Just say that the amended memo of parties filed along with memo dated. Not even a memo, amended memo.
Amended memorandum, my lord.
On 6th February 2025. At pages 1 to 4. Is taken on record. So this coincide with all this thing, na?
Please, my lord, the
Yeah,
article.
yes, okay, taken on record, but necessary correction be made in the memo of parties.
My lord, a short date may be given, my lord, because this is pertaining-
What is the issue here?
So far as main appeal is concerned, minutes, I have not yet received the copy of the paper book in the appeal filed with the government. I'll just collect it from my friend.
So the issue, my lord, is on one side, we have regularization of unauthorized land. And on the other side, the government has granted this land to the employees of the governor. So, my lord, and the learned single judge has not appreciated the issue of the respondents not being in occupation and the suit being dismissed for permanent injunction. That is one issue. And secondly, my lord, when the government order was issued, that is the impugned order, objections were sought for and no objections came forth from the respondents. So these two critical factual aspects have not been looked into by the honorable single judge while passing the order.
Just say it, have it, June, May.
5-6. My
Please.
lord, a
Next.
shorter date, my lord, before the vacation, because
Not possible, man. Board doesn't really permit. Is there any interim order here?
In
There is an
814,
interim.
minutes
There is an-
after the disposal of the writ petition, during the pendency of this writ appeal, but the appellants in the connected appeal, those are the grantees of this land, subsequent to the order passed by this honorable court. They were developing the land. Then I filed an application, seeking an order of interim order. Now this honorable court passed an order directing them not to proceed with the development. That is.
Wherever, in whatever manner the interim
There is
order
an
is there,
interim
will
order.
continue.
There is an-
You are for the appellant in the other one.
It is an absolute interim order, not for.
Actually, it's an absolute.
Absolute.
Okay, it's
And
all
on
right.
the
It's
submission
absolute,
made-
it will stay absolute.
It's based on the submission made on behalf of the appellant.
So we have said till the next date of hearing.
That the order dated 18/12/2024 in writ appeal 814 of 2023.
1812 is there.
Yes, ma'am. There was an earlier order, interim order at the first instance.
stay on the judgment.
For parties to maintain status quo with regard to possession nature of the, say, interim order, if any, to continue. Doesn't make any difference if we continue also
Obliged.
much obliged.
till the next date of. Hmm.
Seventeen.
Yes.
Previous occasion, your lordship, after hearing me for time, my lord, had ordered issuance of notice to respondent number 4 and had also ordered the governmental authorities to secure the records pertaining to the proceedings that were conducted before the before the respondent number 3, my lord. Even the records are also there before this honorable court, my lord.
What is wrong with the order?
Lord, it is a non-speaking order, my lord. It is just 3 lines, non-speaking order. And no reasons have been assigned, my lord, as to
Tell
why.
us one thing. What reasons you gave? What reasons you gave
Lord,
for approaching the court after such a long delay?
Lord, I have stated my reasons in para number 21 and 22 of my writ petition, my lord, or writ appeal, my lord.
No, you show us writ petition.
Yes, my lord. From the lordship, may kindly see, it is forthcoming at page number 15, para number 15 and 16 of the writ petition, my lord.
15 and
15 and 16, page number, in page 34 and 35, my lord. But what happens, my lord, on 25/3/2003, my lord, the assistant commissioner, the respond number 3, says that order will be passed in this matter, and he posts this matter for orders, my lord. Subsequently, my lord, for another 1.5 years, my lord, the petitioners herein, the appellants herein, keep approaching the authorities, my lord. They said orders were not ready like that, my lord. Next, in 2004, my lord, by April and May, my lord, they were told that elections are being held to the Karnataka State Legislative Assembly. So office is preoccupied. So you don't come to this office, at least till the completion of the elections, my lord. Later, what happens, my lord? The file was not raised in the office at all, my lord. Then I was told, my lord, that the assistant commissioner who was sitting from VB Towers, Bangalore, my lord, he was coming to Nelmangla only to conduct these proceedings. Probably the file might have been taken away to the VB Towers. So you have to search the file in VB Towers is what I was told, my lord. So I approached the VB Towers. In VB Towers, my lord, it was not found. Then, my lord, what happened, my lord? The entire assistant commissioner to Bangalore rural office was shifted to Doddaballapur, my lord. So I was told file might have been shifted to Doddaballapur.
We don't understand one thing. You will go to the authority, but you will not come to the court.
Absolutely rustic villages, my lord. For a moment.
Right.
For a moment, my lord. My application filed under section 77A has been rejected, my lord. Now, I would like to submit that, my lord. The reasons why section 77A was introduced, my lord. Lord, on 1/3/1974, what the government decides, my lord, one who is tilling the land, he has to be conferred ownership on such kind of persons, and it amended the provisions of the Karnataka Land Reforms Act, and it provided some window, my lord. Up to 1979, applications can be made before the land tribunal authorities for conferring occupancy rights, my lord. Then the government realized, my lord, in spite of giving so much time,
There are thousands of people who have been left out due to their illiteracy, due to their lack of worldly knowledge. There are still thousands of people who are left out to make their application. So in the year 1998, my lord, after some 20 years, my lord, the Karnataka state legislature in its wisdom thinks, my lord, provision should be given to such kind of rustic villagers who have not made applications. My lord, thinking that, my lord, in the year 1998, my lord, your lordship may kindly see, I have called out the relevant portion of para number 7, sorry, entire section, my lord, 77A, my lord.
My lord, this has been rejected in the year 2003.
Yes, I agree, my lord.
And after 2003,
Is it that, I don't know, we heard that matter the other day. You know that, what is that applications? 1990, there was an abolition of, it's not coming.
the window period of,
That's right.
that is different, my lord.
That's,
The-
this is different.
Yes, this,
For a moment, kindly see in page number 711, my lord.
here, my lord, the learned single judge has dismissed on delay.
Yes.
And it has been rejected in the year 2003. There's absolutely no explanation as to why he has approached this court in the year 2023 after the inordinate delay. And this is an AC order rejection. There is an appeal provision against this order, which hasn't been exhausted. He comes straight away to the High Court without explaining every day's delay as
Right.
stated by the Honorable Supreme Court.
Lord, against the order passed under section 77A, my lord, High Court proceedings is the remedy, my lord.
No.
It's all right, but in any case, a single judge has looked into paragraph 15 and 16 of the writ petition and then pass an order.
For a moment, my lord, your lordship may kindly secure the original records, my lord. Only 3 lines orders, my lord. No reasons have been assigned, my lord.
My lord,
Forget
Correct
it.
For a moment, my lord.
Yeah.
Because, my lord, this is the last.
they have
this
in fact
45 to 50
1
members
minute.
family, my lord. They're absolutely rustic villagers. And the reason, my lord, I agree, my lord, even 5 months, 6 months delay is also fatal in certain kind of writ petitions, my lord. But in this case, my lord, from the year 1950s, my lord, even to this day, my lord, they are all present before this honorable court. When they are present before this honorable court only, your lordship can order the governmental authorities from the local area to secure the records, my lord. They have been peacefully cultivating the land, my lord. There is no opposition to the claim made by the appellants even to this day, my lord. If at all any opposition has to be made, it has to be made by the tenant, sorry, owner of the land, case Puttaswamy, my lord. Even he is also not there, my lord. Even he has also not opposed.
It's
my
all
lord.
right.
The
Then-
lands have been vested in the government, my lord. Even to this day, my lord. Your lordship may kindly see for a moment, my lord. Annexure J, the photograph for a moment, my lord. Even to
We
this
will
day.
not,
if your lordship-
first you have to explain the delay
Yes, lord.
and what is wrong in the order of the learned single judge we are asking you. There is nothing wrong. See, there is a view taken. We are in an appeal.
I'm in the hands of the court, my lord. What I can only request is that, my lord, the institution of the court is respected for its capacity to do justice, my lord. They are all absolute rustic villagers, my lord. They are before this honorable court, my lord. And even the state legislature in its wisdom had thought, after some 20-25 years, my lord, still thousands of people who have been left out, my lord. Now, obligation was cast on the assistant commissioner, my lord, to conduct inquiry, whether it is vested in government, whether they are tenants, whether they are cultivating the lands even to this day, my lord. My lord, no inquiry has been held by the assistant commissioner. Your lordship may kindly secure the records, my lord. It is there before the court, my lord, except 3 lines orders, my lord. Nothing is forthcoming in the order, my lord, impugned order, my lord. They're in the hands of the court, my lord.
My lord, there are 3 issues over here. One is delay. The other is that why has it been rejected in the year 2003 is because they had purchased a certain amount of land. So if they are owners of land, then they are disentitled to get grant land. That is the rejection order, which is forthcoming at the typed version at 142.
Is it a fact
And
you have
then-
purchased the land?
Not 1 acre and 8 guntas was purchased in 1960s. That's all, my lord. 1 acre and 8 guntas.
Will that disentitle you?
No, my lord.
Why?
Absolutely no, my lord.
Why?
Lord, I was tilling this land, my lord, under one case, Puttaswamy. 1/3/1974,
No,
it vested in
this,
the land.
this land which you have purchased on ownership basis,
Lord,
on ownership basis.
only 1 acre and 8 guntas, my lord.
Right. No, how do we get that disentitlement?
Yes, my lord. And 3 families have applied, my lord. And each family is entitled to up to 5 hectares of land, my lord. Can I make the submission, my lord?
Madam, page number? Which is the
One-
impugned order?
147, my lord. 136 is the original, whatever photocopy. The typed copy is 142. The order impugned, this is, and here the appellants have been there during the proceedings, my lord, all throughout. That is the father of the appellants herein. Nagaraju's was the appellant.
Those 2 judgments.
Which one? This list.
These 2 sets of judgments, my lord, for me.
How do we get that? If he has this 1 acre, 32 guntas, he is not eligible for grant.
My lord, that was the instructions. I'm just trying to correlate it to the sections. Because that is the order passed. The impugned order is that they have purchased certain lands to the extent of 1 acre, 8 guntas.
So that is also not forthcoming in the order, my lord. It is completely non-speaking order.
Basically, my lord, first is, there is an appeal provision as per section 118.
Even that will be barred by time.
Yes, and these appellants should have approached the court at an earlier point, at the relevant point of time, at when the rejection happened in 2003.
See, we can't counter and we can't overlook.
Lord, may I just pass on two sets of judgments?
ये सुप्रीम कोर्ट कह रहा है, देखो जजमेंट, ये जजमेंट देखो.
These two sets of judgments, my lord. When it is a non-speaking order, my lord. For a moment, my lord. This honorable court, there are two sets, my lord. The first judgment, my lord, that is 1977, held, the first paragraph. Can I proceed, my lord? Held, when the order of the tribunal is not speaking order, it amounts to no adjudication at all. Such an order is void order. The High Court, when such an order is challenged under 26 and 227 of the Constitution, cannot give its own reasons to support the order, which in effect would mean that the High Court is.
So you should have come first, no?
But I was
This,
completely
your
unaware of-
delay latches would still hit you.
I understand, my lord. I was completely unaware, my lord. They're all absolutely rustic villages, my lord. And my
Right.
lord, I understand, my lord. Even to this day, no third party interests have been created, my lord. The property is intact as it is, my lord. My lord, if some third party interests have been created, had the government granted this to some other person, my lord, I understand, my lord. I'm at fault, my lord. Now, my lord, there are no claimants to this land that is held by the appellants even to this day. And my lord, if at all, if any ownership, any objection has to come, it has to come from K.S. Puttaswamy. He has not come forward, my lord. Lord, just because I have participated, my lord. But my lord, I have narrated what are the subsequent incidents in my writ petition, my lord, from 2003. And there are no records with the government to show that it was ever communicated to me, my lord. There are absolute rustic villages. And my lord, the assistant commissioner from VB Towers, he was coming to Nelamangala. And my lord, records were lost. And they searched in Nelamangala, VB Towers. And then the entire assistant commissioner was shifted to Doddaballapur, my lord. And there they searched. It was not found, my lord, for a long time, my lord. And this thing, what was the answer to the claim made by the appellants was also not known to them, my lord. But they continue to till the land. And there is a report given by the competent authorities in the year 1998 saying that they are cultivating the land even to this day, my lord. It is non-speaking order, my lord. And let them say, if I am not in possession of the land, let them say, if I am not, my lord, all my ancestors' graveyards are there, my lord. I have placed the photographs. Still 2 borewells are running, my lord. Previously, some 6 to 7 borewells I have dug. As successively, whenever those borewells have failed, my lord, I have continued to dig borewells. It is there on record, my lord. Let them get their ascertained from the authorities. They are all before this honorable court, my lord. And this is the last hope to this, to the rustic villages, my lord. This is the last hope to the rustic villages, my lord.
Right. Are we not, reference is made to a Supreme Court judgment. Tell us one thing, 2003, the impugned orders challenged. You challenged the order of 2003?
Not in the writ petition, my lord. Only as soon as we got to know about the side order, my lord, we have approached this.
See, then if we say something, what would be the effect? What value it will have? Precedential, maybe we are at variance with the judgment passed by the Supreme Court. Can we overlook it?
Lord, can I make the submissions, my lord? In respect of this land tribunal matters itself, my lord, there have been several judgments, my lord, of this honorable court, wherein delay of 16 years, 17 years, 18 years has been condoned, and the matter has been again remanded back to the tribunal for fresh considerations, my lord. Let them give reasons, my lord. Let them say I am not in possession of the property.
Then why have you come here? According to her, there is a remedy of appeal. Why did you approach writ petition? Why did you file writ petition? You've taken a chance.
Probably that is my mistake, not.
You have
That's-
taken a chance.
No, that is my genuine mistake, not even to this day. I'm under the false impression that probably, I don't know, my lord.
And how much is the limitation there? Approaching the land tribunal?
Lord, in 1998, window was given, my lord, for a period of 1 year. Within that 1 year period, I have filed an application under 77A before the assistant commissioner, my lord. Well, within the period that was leeway granted by the government, my lord, I had filed. And the proceedings commences only in the year 2002, my lord. For having made an application in 1999, my lord, proceedings commences in 2002 and 2003, my lord. Your lordship, for a moment, kindly see the order sheet of the land tribunal, my lord.
See, even we don't see anything error in the learner single judge order. He goes by 2003. What is error in the order of the learner single judge? None whatsoever.
Lord, my respectful submission is that, my lord, only on the threshold of delay, my lord, let my matter be not dismissed.
Why not?
Kindly look into the merits as well, my lord. Since no third party interests have been created, my lord.
Doesn't make any difference. Person who comes to the court should come in a reasonable time, no? That's the intent. Will that mean that, oh, very well, if third party rights are not being affected, I'll come after 10 years, 20 years, 30 years, 40 years. That's not the law.
Lord, I have explained the reason for delay also.
That's
my
what
lord.
a single judge has done. It is not a case, he did not look into it. He looked into 15, 16 also.
Lord, what the court says in that is, my lord, I had participated before the proceedings in the assistant commissioner, before the assistant commissioner, what he says, my lord. When I have participated, I should not say that I was not aware of the order, my lord. In fact, what has transpired is the file itself was lost for a very long time, my lord. That is the reality, my lord.
I don't think we should take.
I'm left with no other option, my lord.
I just say this, the challenge in this appeal, it's a hard case, you're right. But we are bound.
Lord, let the delay aspect not be considered, let the matter be remanded back to the.
We will
first
not
effect,
say anything.
Lord.
We will not say.
Because only on the ground of delay, they will be dismissing, my lord. Though I am in
Can go.
settled possession, I have been cultivating
this-
that, my lord.
the appeal challenges an order dated 8 December 23 passed by the learned single judge in writ petition 20988 of 2023, whereby the learned single judge has dismissed the writ petition by stating in paragraph 5 as under. Though learned counsel for the appellants would advance several pieces, in view of the fact that the paragraph 15 and 16 of the writ petition, which have been looked into by the learned single judge, wherein the appellant herein sought to explain the delay which had occurred approaching the learned single judge against an impugned order passed in the year 2023, whereby the learned single judge has not accepted the explanation given and dismissed the petition by relying upon the judgment of the Supreme Court in state of Orissa and another versus Mamta Mohanty, 2011 AIR SCW 1332, we are of the view that there is no error that can be found in the order of the learned single judge. It's a conceded position that the impugned order was passed in the year 2023. Howsoever perverse or unreasoned, 2003, howsoever unreasoned be the order, the appellants were required to approach the court immediately thereafter. The explanations in paragraph 15 and 16 refers to the fact that the appellants were approaching the authorities, but that would not really explain the delay and latches of almost 20 years which had taken place for the appellants to approach this court. first, we find no merit in the appeal, the same is dismissed.
Unreasoned order, my lord. Matter may be remanded back to the first appellate authority.
Yes,
Serial number 18.
Only 2-3 lines in the decisions what I have.
yeah, sure,
submitted
sure,
for your
sure,
consideration, lord.
sure.
Can I see?
Yeah, yeah.
Lord,
Which one? 94?
1977,
Yes.
Karnataka High Court judgment, my lord. The first one, my lord. Held, can I proceed, my lord? In the first page itself, my lord. When the order of the tribunal is not a speaking order, it amounts to no adjudication at all. Such an order is void order. The High Court,
The, yeah, okay. Which is the other one?
lord, the next one is para number 6 in this judgment, my lord. Para number 6. It is a settled law that an order of tribunal which is not a speaking order is void in law. Not for this court to sit as an appellate tribunal to examine the record. and
Okay,
justify the
these
conclusion
are,
of the-
these are the same judgments. On a similar point.
Almost on the.
Now, which one is the other?
No, my lord, last one, my lord. Lord, this is a,
94?
lord, 1994, my lord, yes, my lord. Lord,
Yes.
this is a social beneficial legislation. When that is the case, my lord, as far as possible, benefit of the interpretation shall be extended to the needy persons is what the, your lordship can kindly
See,
see.
that,
Internal
that
page
is
number 250,
only
my lord, for a moment, my lord. Internal page number 250, my lord.
internal page
250, my lord,
250.
250. Held,
Which paragraph?
held as at just below 250 is held, and the second paragraph, my lord.
Hmm.
Next to that, the act has to be construed in favor of the consumer to achieve the purpose of enactment as it is a social benefit oriented legislation. The primary duty of the court while construing the provisions of such an act is to adopt a constructive approach. Subject to that, it should not do violence to the language of the provisions and is not contrary to the attempted objective of the enactment.
But was the Supreme Court dealing with the issue of delay or latches there? Or it was only construing in the context of Consumer Protection Act,
In the context of
certain argument. So it should be given a purposive interpretation. That's what Supreme Court said. But here, there is a limitation. Otherwise also, if you have to go file an appeal, there is a limitation. It's prescribed under the act. You did not avail the remedy. You came to the learner single judge straight away from 2003.
that is my mistake, my lord.
Sorry, right? We are only explaining you this judgment.
At least, my
Just say
lord,
that-
liberty may be reserved to approach the appellate authority, my lord.
We
And
will
without-
not say anything. No, nothing.
Without being influenced by anything said in this. That is the only option, my lord. Some 45 to 50 poor illiterate persons are dependent on this land, my lord. For a moment, your lordship, kindly see the photographs, my lord, for a moment, my lord. They are in peaceful cultivation of the land, my lord. For a moment, kindly.
We
see
are
the-
with you. It's a hard case. Maybe you have to go to Supreme Court and get it this thing. We are bound by all this law, and there is a judgment referred by the learner single judge. We have seen that judgment. See, 2003, how can we condone, how can we overlook the delay latches?
The file was not traceable, my lord.
We, will-
That is
we,
understandable.
that's no ground for you not to approach the court. How are you concerned the file is not traceable there? You are not concerned. You should approach the court.
But when the orders were not at all communicated to me, my lord, there is
That's-
no records with the government also to show the order was ever communicated.
It's all right, please. You're right. Okay. Just say insofar as the judgments relied upon by the learner counsel for the appellant in Veera Lakkappa Devakatti and Enna Nanjuda Shetty, of this court. No, in Radhakrishna Shetty and Emma Nanjunda Shetty. The learned counsel had relied upon on the proposition that if the impugned order is void, comma, if the impugned order is a non-speaking order, it amounts to no adjudication at all. Such a order is void. When challenged before this court, the High Court cannot give its own reason to support the order, which would mean that the High Court is taking upon itself a learned land tribunal. Suffice to state, such judgments have no applicability. even if it is the contention of the learned counsel for the appellant that the impugned order was an unreasoned order, nothing precluded the appellant to approach this court immediately on the passing of the order. Full stop. In fact, the learned single judge has rejected the writ petition only on the ground of delay and latches. Full stop. And hence that said judgment has no applicability. Insofar as the judgment in the case of Lucknow Development Authority versus M.K. Gupta, 1994 1 SCC 243 is concerned, the learned counsel has relied upon paragraph 2 of the impugned order to say that the court, while construing provisions of an act, should adopt constructive approach, subject to that it should not do violence to the language of the provisions and is not contrary to attempted objective of the enactment. Full stop. The said judgment has no applicability. The issue in this appeal is not the interpretations of the provisions of, which is the act under which Karnataka Land Reforms Act.
Karnataka Land Reform.
Karnataka Land Reforms Act 1961. The issue is with regard to, whether the challenge before the learned single judge to an order passed by respondents on 15 June 2023 is hit by delay and latches. Stop. The learned single judge has answered the same in the affirmative by relying upon the judgment of the Supreme Court in the case of State of Orissa versus Mohanty. Stop. And hence the judgment being not applicable. And hence there is no issue relatable to the interpretations of the provisions of the aforesaid act. The said judgment has no applicability. We do not see anything.
No proceedings at all are conducted.
Which page?
Dated,
Well grounds in my appeal.
Come to 136.
Yes, ma'am.
What is the left-hand side? Nakalu. What is the date?
19-2.
2003.
It can't be 2003 because that order itself is 15/6/2003. So it is something thereafter, maybe 2007.
But no proceedings at all are held before this tribunal, my lord.
Who had taken this? That's a certified copy. You have the file?
Yes, my lord. I have the original file,
What does it say?
19/2/2003.
2003, it can't be. Okay.
This also clearly shows. But it appears they have superimposed this last page of some other proceedings into this page, my lord. There are no proceedings that are held, my lord. Your lordship may kindly see the case papers. Even they cannot also make out what is this, my lord.
And
Yes, my
my
lord.
instructions are that this is 19/2/2000.
Who has filed this document? Who has filed this document? You have filed it?
I have obtained the certified copies and I have filed, my lord.
You obtained in 2022. One. That's right.
It is 19/2/2000.
And there is something which was obtained in 2007 also. Okay, thank you. Next.
Lordship may see the original records for a moment, my lord. You can lordship may kindly see the original for a moment, my lord. No proceedings have been held at all, my lord. That is the only this thing, my lord.
This is the
And the
question.
file was lost for a very long time.
Again, you are making the same submission. How is that relevant for you to approach?
Yes. That is forthcoming from the records. It's not 2019/2007.
No, is the application on record?
Yes.
Yours?
6/1/2007.
These people were depending on the middleman, my lord. They're all rusty villagers. That's all I can say, my lord. When no proceedings are held, my lord, it is not a
What is
non-complete.
the name of the gentleman? What is the name?
I'm not aware, my lord.
That's 6/1/2007, you applied for a certified copy.
I'm not aware, my
19/2,
lord.
it was granted.
I'm not aware, my lord.
File says so. What is the name? What is the name here?
One Nagaraju is appellant number 2 in this case. However, the records are in now the hands of the court, my lord.
Okay, thank you.
Lordship, kindly, the records of the land tribunal, for a moment, my lord. No.
We have seen
proceedings
it. We have passed the order. The 2007 also, we can see it. Next. Pardon?
There was a direction to the learned government association to support the original report.
Okay. Where is 22 application? This. On which date the record was called for? What was the date in this appeal? Additionally, we may state here that on 27/9/2024, this court had asked the counsel for the respondent to produce the relevant record. The record has been produced before us. We find that on 6/1/2007, the request was made for a certified copy of certain documents. Similar request was also made on 10/8/2027 by Rangaraju, one of the appellants herein. Appellant number 4, which includes and there is an order passed by the concerned authority to give the documents in accordance with law. So it appears that it is not a case where the appellant had not pursued with the respondents. They had sought for the copies of the orders passed, statements recorded, etc. Of having not pursued the remedy even thereafter. We are of the view that the final conclusion drawn by the learned single judge cannot be faulted. Thank you. Just give it back. This is-
Serial number 18, Shri Narayan.
Yes, ma'am. What are your instructions?
Let's, I may be permitted to read that para 9, that 92 page number minutes. Last time my lords asked me to get instructions on that. I'll make one submission and then I'll leave it to the discretion of this honorable. Page 92. On his selection in the ITI Limited, Bangalore, Shri Mohanlal submitted his resignation and was relieved from the DRDO on 31/1984. On the basis of his resignation letter dated 31/12/1983, his lien with the IB was terminated with effect from 31/1984. The LRD DRDO was requested by us to remit his leave salary and pension contribution for the period from so to so. However, the LRD authorities, vide their letter dated 27/1/2009, replied that as Shri Mohanlal was retaining lien with IB, there is no provision to remit the leave salary and prorata pension contributing as per rules. Well, my submission is, now DRDO is telling that I have retained the lien, but actually I have terminated the lien because he has not come back to me, one thing. Secondly, he has resigned in DRDO on a particular date, that is 30th January 1984. And the same day, he has, my lord, seeks relieving from me. So it essentially means that he has not come back to me. So
No, he came and then he submitted his resignation and then went.
Well, it
He'll
was
be
on the same
entitled to
day.
for 10 years. Tell us one thing. You got the money back from the ESI, EPF?
My instructions are that I have given it back to Pay and Accounts Office, and from there it has gone to Consolidated Fund of India.
Obviously, it has to go because everything comes from their consolidated fund.
Yes, ma'am.
It has gone back.
That's
It
what
should
is
have
my
come to him.
instruction.
Simple. He's entitled to in law. He should get it. Yes, now tell us why, how. You would only get that amount. No interest, nothing. When did you file the petition?
2008, my lords.
2000?
8 initially.
And when was the first request made? First.
Yes.
And where is their representation? Which page?
Page 64, my lord, is the one addressed, my lord, by the Intelligence Bureau, my lord, to the ESI.
What happened to this?
My lord, on the basis of this, my lord, the SIB, IB, my lord, remitted to the ESI. Then, my lord, they sought it back on the ground that, my lord, I had joined the ESI and not, sorry, I had joined the ITI and not the ESI.
Just say this challenge. So now when did you file the OA?
My lord,
2010,
my lord.
Okay. The challenge in this petition is to an order dated which page is the impugned order?
Impugned order is at page 185, my lord. It is the second round.
Is to an order dated 25/4/23, whereby the OA filed by the appellant petitioner has been dismissed. The prayers in the writ petition, the prayers in the OA for the following. Page 185. The petitioner had joined the Subsidiary Intelligence Bureau SIB under the Ministry of Finance and Ministry of Home Affairs. Full stop. On when did you join there?
My lord, I joined, my lord, on 26 February 1973.
26 February 1973. While working in SIB, he had made an application for appointment in LRDE, bracket DRDO, Indian Telephone Industries Limited, bracket ITI, Employee States Insurance Corporation, ESIC, and Employees Provident Fund Organization, EPFO. The posts of LRDE, ESIC, and EPFO were pensionable posts. The applicant, on his appointment to DRDO, joined the DRDO by retaining the lien in the SIB though the OA has been filed, the aforesaid OA, DRDO, the aforesaid OA just say this, pensionable post. The petitioner had approached the tribunal in the year 2010 by filing OA 288 of 2010, challenging a communication dated 3/5/2010, issued by the SIB, and communication dated 19/6/2012, issued by ESIC, seeking a direction to the respondents to pay areas of pension due from the respective departments. So the said OA was disposed of by the tribunal on 5/11/2012, directing SIB to process the papers of the petitioner and forward them to ITI, who in turn will forward the same to ESIC Corporation. The ESIC Corporation was to proceed and accept the payment from the petitioner on pro rata basis towards contribution for the period with ITI. Be that as it may, that the SIB had finally passed a memorandum dated 23/2017, wherein SIB has stated as under. Which page is that? 23/2017. Which is that page?
My lord, annexure 820, my lord.
Annexure?
820. My lord, it is at
110.
page 110, my lord.
Annexure 820, page 110.
Yes, my lord.
Full stop. Wherein the SIB has stated as under. Full stop. Today, it is this order which was challenged before the tribunal, and the tribunal has rejected the OA filed by the petitioner. Today, we have heard the counsel for the parties on different dates. Full stop. The submission of the learned counsel for the petitioner is that he shall confine his prayer to the extent that the petitioner shall be entitled to prorata benefits. Will it be pensionary?
Pensionary.
Prorata pensionary benefits for the period of service put in by him in SIB and DRDO, which according to him is more than 10 years. This in support of his submission, he would contend that when he applied for the post in DRDO, LRDE bracket DRDO, he had applied through proper channel. When the petitioner got appointment in LRDE bracket DRDO, he joined the LRDE by retaining the lien in SIB. His submission is also that before he could complete 2 years, he had come back to the SIB and tendered the technical resignation on 31/1/1984.
On
31.
30th January.
30th January 1984, which was accepted by the SIB. Pursuant thereto, he has joined the ITI. He also clarifies, since he has joined the ITI. He also clarifies that ITI is not a pensionable service and he cannot claim any benefits pursuant beyond his joining the ITI. Full stop. He has also drawn our attention to, where is that letter, ma'am? You have written to this ESIC also,
That is at page 90.
page
It's only mentioned, my lords.
Page 92, my lord.
92.
91,
He has also drawn our attention to,
92.
to a to the reply filed by the respondents at page 92 of the paper book.
64, my lord.
Huh?
64, sorry. One is at 62 and another is at 64.
So 63 and 92 and 64 are same, na?
94 is.
No, we will come to that,
What
wherein,
the objections, my lord?
wherein the following has been stated. Stop. That apart, during the course of hearing, our attention has been drawn to, where is that communication, ma'am, when you said that you have written to ESI to, you just pointed out, no?
That's also in the same parameters.
No, you said there is some separate communication. You just pointed out where you have asked for the money to come back.
That's that I've not placed any document. It's just my instructions.
So you are referring to this only.
Yes, my lords.
Was it not a communication?
No, my lords.
Okay. The following has been, according to the counsel, from the aforesaid stand of the respondents, it is clear that it is the case of SIB that the pension contribution for the period of service put in by the petitioner in SIB from 26/2/73 to 31/1984 amounting to 9041 was sent to the ESIC Corporation by the SIB. However, the ESI Corporation Bangalore had requested us to send the lump sum pro rata pension and DCRG terminal gratuity to them, counting his last service. It is also stated, he has also drawn our attention. It is also, we note the stand of the SIB in the reply is also that the petitioner can be given pro rata pension benefits for the service rendered in IB together with the LRDE. And this amount the said amount can be granted to him only on the basis of the option exercised by him as per the provisions of the relevant rules. To stop. Today, the learner counsel for the respondent states, as per her instruction, the ESIC has sent has deposited, ESIC has deposited.
Yes, my lords.
ESI returned it to them.
ESIC has refunded the said amount to SIB, which in turn deposited the amount in the consolidated fund.
PFA and then consult.
In the principal
Payment and accounts office.
payment and accounts office, which ultimately deposited in the consolidated fund. The aforesaid facts clearly demonstrate that the petitioner shall be entitled to the pro rata pension having put in more than 10 years of service. 10 years of service in IB, SIB and DRDO and LRDE, from which he had returned back to SIB before going to the ITI. The issue now which arises for consideration is, full stop. Just cut that last sentence. The petitioner having, from the above, it is noted that the petitioner had filed the writ petition in the year 2010. In the year 2010, having made the representation for the first time in the year 2008. So in that sense, effective from 2008, he has been pursuing the issue of grant of the benefits benefits in his favor. Full stop. Yeah, in his favor. In view of the submission made by the counsel for the petitioner that the petitioner shall confine the benefits for the pro rata pension for pro rata pension having put in more than 10 years of service, both in SIB / LRDE, DRDO. He is entitled to the same. Full stop. If that be so, and also noting the stand taken by the SIB at pages 92 and 93. Just produce 92, 93 full. Huh? We are of the view that the petitioner shall be entitled, the impugned order of the tribunal they say that we find that the tribunal has rejected the OA by referring to Rule 26 of the pension rules, which according to which stipulates forfeiture of service on resignation. Full stop. On resignation, and also Rule 37 of the pension rules, which stipulates pension on absorption in or under a corporation, company or body. Full stop. Since the petitioner is only confining to the benefits in SIB / the LRDE, and the fact that the petitioner has applied for the appointment in LRDE through proper channel, and he having got appointed in LRDE to where he joined with a lien of 2 years in the SIB, and having come back and tendered technical resignation to enable him to join the ITI, we are of the view that the petitioner shall be entitled to the pro rata benefits of the period of service put in SIB / LRDE. And it is full stop. Further, it is the case of the SIB as contended by the learner counsel on instructions that the amount sent to ESI was refunded back to the SIB, which has been through Pay and Accounts Office deposited in the consolidated fund. Full stop. If that be so, the petitioner shall be entitled to pro rata benefits, benefits of having put in a pro rata pension. You're saying only pension, no?
Yes.
Pro rata pension for 10 years of service, or for the years of service put in by him in SIB / LRDE, which we have been told being for the reason, just cut that, this for the reason that both are pensionable services. The question would now be, what should be the interest on the said amount that need to be paid to the petitioner? The petitioner has been pursuing the remedy for grant of the benefit since the year 2008 / 2008, when he made the representation for the first time. Which page? On 25th April 2008. Full stop. The
A2.
Full stop. If that be so, the amount, the amount, the pensionary benefits shall be paid with interest. The rate of at the rate of 9% per annum. To be paid, to be released in favor of the petitioner within a period of 3 months from today. 3 months from the date of receipt of the certified copy of the order. Okay, with the above, it may be stated here that in view of our above conclusion, the finding of the tribunal that Rule 26, in terms of Rule 26 of the pension rules, having tender resignation, the service stands forfeited, is clearly untenable and erroneous. Surely that cannot be the interpretation in the facts of this case when the application has been sent through proper channel. Full stop. Then, and having said, and insofar as Rule 37 is concerned, that has no applicability in the facts of this case. It is not a case where it is not a case, more so when the learned counsel for the petitioner has confined his prayer for the grant of prorata pension for the years of service put in SIB/LRDE. LRDE. And in that sense, there is no question of the petitioner getting absorbed in a public sector, in a corporation or a public sector body for Rule 37 to be applicable. We dispose of the impugned order of the tribunal is set aside in view of the fact that the writ petition has been pressed only for the limited relief. We allow the writ petition and dispose of the same. Okay, no cost.
Lord, he may get the pension, my lord, it is a continuous process that your lordship may kind of do.
Pardon?
My lord, pension on month-to-month basis, my lord, he may be.
He would be getting month to month. And just say that, and on grant of such a pension, comma, the respondents shall act. Other than he would be entitled to arrears also.
Yes.
Prorata pension, it's not a one-time payment.
It is not a one-time.
And accordingly, the petitioner shall be entitled to the, in view of this judgment, comma, the petitioner shall be entitled to the arrears of pension. Arrears of pension from the date it is payable till date, that we will compute it. It would be also on the 9% only, we'll say. Okay? Thank you. Yes.
19, serial number 19. Shri Manu.
Appearing for the appellant, my lords, I seek a short accommodation. The matter may be had on 27th. The matter is already part heard. We had commenced our arguments on the last date, my lords. There's some inconvenience today. It may be had on the 27th.
At the request of counsel.
Written synopsis, my lord, along with judgments, for the respondent. Because the final bill is not yet paid, though the work was completed.
No, what synopsis you say?
In the written arguments, in respect of the.
You have filed it?
No, not yet. If your lordship permit me, I will file it. They are, see, final bill not paid, escalation bill is not paid, though the work was complete 10 years back, my lord.
At the request of counsel for the appellant, adjourn to.
May be had on the 27th, my lords.
No, we will give our date, ma'am. The learned counsel for the respondent shall be at liberty to file written submissions along with the judgments he wants to rely within 3 weeks.
$19,600.
Obliged.
Serial number 20.
Just 1 minute. Just have it in April.
Short date.
You just tell that.
Madam, serial number 19.
Please, my lords.
74. Madam, 74.
Obliged.
20, serial number 20.
Your lordship, and for the appellant, your lordship, I seek for 2 weeks of time. I need certain instruction from client, your lordship.
How would you answer the delay?
2 weeks time may be
At the
granted,
request
your
of counsel for the appellant, adjourn.
22-4. Serial number 21. Shri Arun BM.
For the appellant in the first matter and respondent in the second matter. That's last time also they did not come.
Just shows this, ma'am.
Concurrent findings by both the tribunal and the.
Last time was the reverse of today's. You were not there.
They took time, my lords, last time. My friend was not there. The court was ready.
The
but-
last order say none for the respondent.
Yes, they did not come. The respondent in the first matter,
You are for the appellant?
appellant in the first matter.
Oh,
My lords, in the second matter is the main matter. There is an interim order not to execute the award, my lords. I am stuck, my lords, in the matter. The only question is, I'll just take a minute's time of your lordship, my lords, in the nature of the matter. It's a 4 acre, 20 guntas of land a partnership firm purchased by obtaining a loan of 1 crore, my lords, in 2008. Thereafter, they did not do any business. Now the firm is dissolved. Only land is available, 4 acres, 20 guntas. I produced a sketch for them to take whichever portion of the land they can take. They did not accept, then we moved in arbitration. The arbitrator has passed an award allotting one portion of the property to me, one portion to them. That is put in execution. In the meanwhile, they filed an appeal before the district judge, appellate court. That award is upheld. Now there is an interim order. That interim order was granted. That day the court was not free at 4:30, my lords. Now 5 years over. They are not cooperating with the court. Any number of times matter has come up, my lords.
just say we find there is no appearance for the respondent. Respondent in Comp 68, 2021. There was no presence for the respondent even on the last date of hearing.
Appellant in second matter. They are the appellant in second matter. That's the main matter.
Where is the interim order? Is it? in the
Interim order is
second-
in MFA, my lords, 1650.
MFA.
Please.
Also, just cut that. Just cut that. There is no appearance for the appellant in 1554 of 2021. We find there is no there was no appearance for the appellant in the same appeal, na?
Please.
On the last date of hearing also.
Also.
So in the interest of justice, re-notify, just give it first week of April. Where is the interim order?
Yeah, on 20, your lordship may kindly see 17/8/2021. 17/8/2021.
Interim order, if any, to continue.
Not to proceed the execution.
That's all.
Please,
We'll see on the next date.
please.
7-4.
My lords, in the, they have filed an amended appeal, but physically they have not amended the petition, my lords. My lords may pass an order regarding that. Let them carry out the amendment. One of the parties is dead. They have filed the amended appeal. There is a direction for them to carry out amendment, my lords, that they have not done.
Amendment where?
Amendment in MFA, my lords. Only
Okay.
party has to be deleted from the array of parties.
That's all, only limited.
Only the limited, that,
Just say that the counsel for the appellant in MFA 1654,
he has
Shall
filed an
carry out
amended appeal and served.
necessary amendment in the cost item,
Please,
before the next date of hearing.
please. Grateful.
22, 23 adjourned, 24, serial number 24. Is Syed.
Louder, use the mic.
Yes, my lordship, we are for the appellants in this. Senior counsel is argue from the Delhi, he is not available, Jayant Mehta. So maybe adjourn for a week.
Who is the other side? At the request of counsel for the appellant, adjourn to.
19-6. Serial number 25,
Connected matter, my lordship, connected matter. it is.
19-6,
Grateful.
26. Serial number 26, Srimati Vandana.
Before the respondent,
Some mention in the morning.
morning, it seems they have mentioned,
Huh.
but the last occasion, the learned senior counsel sought for the time to seek the instruction regarding the deposit of the amount. This is a money recovery suit.
In which petition proceedings an IRP has been appointed?
No, they are not. On the last occasion,
See,
submission
that
was
is what was represented in the morning. We'll just pass over.
much.
Next.
27. Krishnamurthy.
You ready?
Ready, my lord, sir. Notice is not yet ordered, my lords. My suit has been on the ground that, my lord, sir. My appeal is filed on the ground that, my lords, no notice has been issued while terminating and blacklisting the appellant. And the tender has been granted, my lords. I am regular in serving the 250 gangmen to the 3 divisions, my lords. And they say that, my lords, they are served the notice stating that, my lords, you have to produce the payment bills and other things to the gangmen, my lords. And insofar as payment of EPF is concerned, my lords, my appeal is pending before the Central Industrial Tribunal, my lords. Without considering all those things, without giving opportunity to me, my lords, by invoking clause 20, first respondent cancels the tender, my lords. It's not within the jurisdiction of the first respondent. It's a power of the second respondent to cancel the tender, my lords, by giving opportunity.
Issue. Just say issue notice.
Please.
17. 28.
2 and 3, my lords. Here for the appellant. First respondent.
Paperwork is produced, my lord. Here for the appellant, paperwork is produced.
What?
Paperwork has been produced. Last date it has been.
You have produced?
Yes.
You have filed it?
Filed.
You got a copy?
We got the
Yes,
copy.
I got it.
Paper books stated to have been filed are not on record. Are they record? First, stated to have been filed. Just say paper book stated to have been filed. Re-notify on.
23-6.
My lord, a short date may be given. Aged person. 8
Not
years.
possible. Next.
29. Anjuna.
Every month we'll be having almost like 10-20 darshana. So we
I seek for password, my lords.
Password.
30. 30.
For the respondents, please.
My lord,
Yes, ma'am.
previously we sought the matters to be connected and it has been connected. We have a small difficulty. Senior is hospitalized since a week. I appear on behalf of G. Balakrishna Shastri, my lord.
Yes.
Senior is hospitalized, so may I request for an adjournment in the matter, my lord?
Is hospitalized. Yes, a request is made on behalf of, what is the name of the council?
G. Balakrishna Shastri.
Mr. G. Balakrishna Shastri is indisposed. Registered.
April
23-6.
6.
Still number 31.
31, my lord, I appear for the appellant in the matter. My lord,
We'll come back.
please.
Number 31, Shri K.V. Narasimhan.
Appear. Lord, the appellant, being the writ petitioner, my lord, had called in question the appointment of the third respondent to the post of an assistant professor in Bangalore University. Lord, the contention that was taken up is I had not been given the marks that I am otherwise eligible to, and couple of marks added to me would make a huge difference, by the virtue of which I would be appointed. My lord, this contention had not been considered at the outset, and my lord, the writ appeal was filed by me. My lord, in the writ appeal, this honorable court, my lord, held that the matter will have to be taken a relook by the learned single judge, by specifically looking into my contention as to whether I was entitled for the marks that I am claiming or not. By the virtue of which, my lord, a remand order was passed, and the learned single judge, my lord, was directed to look into my case on merits. My lord, on remand, my lord, an order was passed on 13/10/2017, asking me either to elect between the writ petition or the work that I am doing. Now, I was working as a professor in Vishweshwaraya Technological University. Now, I was asked, first you resign that post and then come back here and prosecute the matter. Now, that order, my lord, I sought recall before the very same learned single judge. Said that I would be interested in prosecuting the matter, but resignation would be difficult at this point of time because I need to work somewhere until and unless all these things would come to a logical conclusion. My lord, by the impugned order, my lord, only citing the order dated 13/10/2017, my lord, my case has not been considered on merits. Now, the learned single judge dismisses my petition, reiterating the order dated 13/10/2017, and says that you have not resigned from the post of VTU and hence you cannot prosecute this matter. Now, I need to, my lord, keep my working to meet my day-to-day needs. Now, I have made it clear that I will take up this post on the matter being prosecuted. That is the recalling application specifically I filed. That is not entertained, and my lord, the petition is dismissed. This is all by the order, my lord, passed by this honorable court. May I just pass it on, my lord? In the previous round, when the writ petition had been rejected, this honorable court, my lord, relegated the matter back to the learned single judge to hear me on merits of the case. There were two contentions, my lord, that was raised by me then. One is that I had the requisite teaching experience, and second is the marks had not been allotted. Before this honorable court, in the writ appeal itself, the other side considered that I had the requisite teaching experience. Only the fact that remained to be considered was whether I was to be given the marks that I claimed. And specifically, my lord, it was stated in page number 6, paragraph number 8, as hence this court deems it proper to remand the matter to the learned single judge to consider the marks obtained by the appellant and to decide whether the appellant is entitled to extra 3 marks, which he claims that he is entitled to, and to adjudicate on the respective merits of the case.
How are you now concerned with the appointment? Where are you working?
My lord, I am working in VTU. I have stated specifically that there was some
So how are you
allegation.
concerned with Bangalore University?
No, because this is where, my lord, I have made an application for, and this is where I am contesting for. In my application, I specifically stated that I'll give that up, and I'll take up this. This is what I have categorically stated in my application.
Where are you? Where were you working in 2015?
2015, my lord. Lord, Lord, I was initially, my lord, when the petition was filed, I was working, my lord, in Ambedkar Institute of Technology in Malathalli in Bangalore, in the Department of Computer Science. My lord, during the pendency of the petition, my lord, I apply and I get a job in VTU. That I need to pursue because I need to earn something for my livelihood. And when it came to, my lord, choosing between the two, I categorically said that I'll take up this and I'll prosecute this matter. Because until that happens, I need to have my earning. This I have made a categorical statement, my lord, by filing an application seeking recall. Now that is not considered, and my lord, straight away, my lord, the earlier order has been reiterated. Now this honorable court had relegated the matter to the learned single judge only to look into the merits of the matter. All that had to be seen is whether I was entitled for the additional marks that I had sought or not.
Now, when this order was passed by the division bench,
Yes, my lord.
what does division bench say?
The division bench, my lord, directed the learned single judge to look into the merits of the matter regarding my entitlement of the additional marks that I sought. Where I said that having regard to my educational qualification, I ought to have been given 5
In which university?
I passed out, my lord, from the Bangalore University.
No, this challenge here
Yes, my lord.
is to which university?
My lord, to the Bangalore University.
Was there any challenge to any appointment made?
Yes, my lord. That's a remand order that I have produced before my lord.
Now, what happened after 2017
The matter was taken up, my lord, in the writ
by the
petition.
learned single judge,
Learned single judge.
which resulted in this order?
In this order.
So we will only confine ourselves to the marks.
My lord, that is what, my lord, was specifically directed by this honorable court, my lord, to be looked into by the learned.
Did you join this Visveshwaraya?
My lord, in the year 2015, my lord. I responded to a application of the year 2013.
And what is the position there in Bangalore University?
Pardon, my lord.
What is the position? What is the appointment? Which post?
My lord, assistant professor.
So you are today professor.
My lord, of course, but I have stated and I have elected that I would still like to prosecute because still there are some difficulties there and the appointments are still seized off by this honorable court.
Now, how many marks you were short of?
My lord, I was short of 3 marks.
Okay, now how are you claiming those 3
My
marks?
lord, I am claiming, my lord, on this point. That, my lord, as per
Even
the,
appearing for respondent number 3.
pardon, notice have to go, my lord.
Just say notice. Returnable on.
27.
Please. But as far as R1 and R2 is concerned, may also be permitted to take upon the learned counsel who appeared before the learned single judge. Panel counsel, my lord, by name Shri Rajendra Kumar Singhe.
Additionally, liberty is granted to serve the counsel for respondent 1 and 2 who appear before the learned single judge.
Please. Great.
32, serial number 32, government advocate.
Yes, ma'am.
Appeal by state, my lord, against the order of learned single judge. Your lordships may kindly see in page 15, the impugned order, my lord, a common judgment is, order is passed. Lord, the third respondent, my lord, that is the the claim of the respondent is, my lord, they are claiming pension and other benefits. That was the claim before the learned single judge. Apparently, my lord, that writ petition came to be allowed. Lord, now, my lord, the third respondent herein, my lord, that is the Karnataka Media Academy. They have also preferred writ appeal. And so also, my lord, in writ petition 41264, my lord, Muni Raju, he is also preferred, my lord. Lordships may kindly permit me to
When are
give the
those-
memo, my lord, that all the three appeals be connected.
Which year, just?
24. Lord, the other
Will
writ
be our
appeals, they are
jurisdiction.
being listed on
This will be our Boston. The learned counsel for the appellant states that with petition number,
267 of
appeal
24
number 26724.
and 164.
164 of 24, arising from the same impugned
Please, my
order.
lord, same impugned order, my lord.
Arising from the same impugned order
Lord, they are listed on 36, my lord.
are listed
36,
3/6/2024.
please, my lord.
It was listed here.
Please, my lord.
She states that this appeal be listed on 3/6/2024 along with the aforesaid appeal. It is ordered accordingly.
Oblige me.
2/6/6.
Serial number 33. Okay, Mahesh. 33.
Appellate.
For the respondent.
Lord, in this matter, I am questioning the order passed by the learned single judge. The learned single judge allowed the writ petition filed by the petitioner. My lord, that order, my lord, facts of the case is this, my lord, you will also may kindly see that the petitioner herein, as a respondent, submitted a caste certificate at the time of his appointment, as he belongs to a Naika community, which comes under the scheduled tribe category and appointed as a craft teacher by the Netaji Seva Kendra, my lord. My lord, thereafter, the respondent appointee has come to the notice of this thing, he is not belongs to a Naika community. Then the matter was referred to the caste verification committee. Caste verification committee come to the conclusion saying that he is not belongs to a Naika community. My lord, they cancelled the certificate issued to him by my lord. Against that order, my lord, he preferred an appeal before the authority concerned. The authority concerned not said the matter. In the meanwhile, the appointing authority dismissed him serviceman. The caste verification committee given a certificate, the order in question passed by the caste verification committee, may kindly be looking into my lord, you are also may kindly see. What is the finding given by the caste verification committee? May I read to your lordship?
Page.
Ink page, my lord, Annex C. Ink page translated copy at Annex 49, my lord. May I read to your lordship?
Yes.
It is confirmed beyond any doubt that Sri Narendra Nayaka, AL, brother of the Somasekara, he belongs to a category 1 Parivara caste. He has obtained a false Nayaka caste certificate of scheduled tribe. And in the caste verification committee meeting held on 28/11/2017, it was decided to take legal action against him for having obtained a false caste certificate by cancelling this caste certificate. Even though it is confirmed that Sri Somasekara has also obtained a false caste certificate, an opportunity was extended to him in the caste verification committee meeting held on 25/2/2019 to confirm his caste. But till date, Somasekar, the so-and-so, has failed to produce any proper document to show that he belongs to a Naika caste after considering all these facts by the committee. That is Somasekara, who he belongs to a Parivara caste, falls under category 1, belongs to backward class, and not belongs to Naika caste, belongs to the scheduled tribe. Thus, it was decided that the Naika caste certificate, which belongs to Scheduled tribe, issued by the Tahsildar Carpet to Somsekhar, is invalid, and also it was directed the Tahsildar Carpet to cancel the caste certificate issued to him and direct the Superintendent of Police, Director of Civil Rights and Post to take legal action against him for having obtained the false caste certificate. The order in question passed by the authority concerned on 12/7/2019. This statutory committee order communicated to the authority concerned. Then thereafter, they dismissed the person who has obtained a job by giving a false certificate on to dismiss him on.
But now, post 2000, Parivara and Nayaka are one.
No, on that day it is not Parivar or Naik. Subsequently, in the year 2020, they issued a notification to that effect. My submission to your lordship in this matter, this is it pertains to the service matter. It is not coming to effect from the date on issuing a notification, from the date on which the act came into force.
Today, in any case, both are one.
Right?
Today, Parivara and Nayaka are one.
Because of this notification, they have said that Parivara is also considered Nayaka community.
So that means, is it an ST community or a backward?
Earlier it is a backward. Now it is scheduled tribes.
Now it is scheduled.
Scheduled tribes. Because of the notification 2020.
Against which post he has been appointed?
As a
Against
cross
the-
teacher.
No, as an ST candidate or a
ST candidate. As an ST candidate.
against the backward certificate.
Not backward service. Obtained a Naika caste as belongs to Naika, even though it not belongs to a Naika. On that day, he was pertains to Parivara community. On that day, on the date on which obtained a certificate. On that day, it is not included. On that day, it is not included as Naika, as a Parivara. It is included, it is given notification in the year 2020. On that day, it is not belongs to scheduled tribes. He belongs to a Parivara. He obtained a false certificate saying that Naika caste. Then he got a job. My submission to your lordship in this matter, the day on which notification issued is a prospective in nature. It is not retrospective in nature. On the date on which you obtained a certificate is a false certificate. He does not belong to a Naika community. He belongs to a Parivara. On that basis, verification committee conducted an inquiry, cancelled the certificate issued to him in the year 2019. The notification comes to
What do you say?
2020.
On the date when you got the certificate and appointment, you were which caste?
I was Naik.
Nayaka.
I was Naik. My fathers and forefathers and even his forefathers were also belonging to Naik.
Now,
We never,
what about Parivara?
Parivara, it is a strange thing for me.
It is a,
Some third person might have alleged that I am belonging to Parivara. That is someone,
Where is
Nagendra
your-
Naik or
where is
Narendra Naik.
where is your earlier certificate?
Earlier certificate, even my fathers, forefathers, everybody, they have obtained Nayaka as their
Where is
certificate.
that certificate?
I have already produced, my lord, before
Here.
the concerned authorities.
Where is the certificate? First
Sir,
certificate?
Annexure A is produced.
Yes. Page 20.
Annexure A2, sorry,
That
and
point-
A1 and A2.
That point of time, my lord, they thought that Parivara and Nayak are synonym. Both are equivalent.
Who has thought?
Lordships, that is the finding. If my lords may kindly see in page 14, para 4. The learned single judge has observed that.
Let's see that.
And the circular is at page 39, my lord. Para 4, my lord.
But did your brother obtained a different caste certificate?
He is not my brother, my lord. He is some other, my brother's brothers.
Brother is your brother.
No, brothers, my father's brother's son.
So it
Because there
was-
was enmity against us, he raised that I am belonging to Parivara, not himself.
No, you're not understanding.
I know, I can understand, my lord.
You
My,
understand? Huh? Yes, so what do you say?
no, I belong to Nayaka only. My fathers were also belonging to Nayaka. My forefathers are also belonging
How
to
would
Nayaka.
you answer Parivara caste?
Parivara, I have never said that I am belonging to Parivara.
But your fathers, brothers, son.
Everybody
So
were
you
belong.
said now, who is the name? Narendra Nayaka.
And it was considered, Narendra Nayaka is the son of my father's brother's brother, a distant one, because of enmity between the family members. He said that I am belonging to Parivara, but not Nayaka, he said. But let him prove that Parivara, I was actually belonging to Parivara. I have never belonging to Parivara even prior to that amendment order also.
No, no.
Right from the beginning.
Nayaka is a scheduled tribe caste.
Yes, scheduled tribe only.
How you were appointed to which post?
ST post only. As a craft teacher, I was appointed against a scheduled tribe, post reserved for scheduled tribe. Nayaka. Nayaka caste was a scheduled tribe.
On 28/11, when were you appointed?
In the year 1997, my lord. About 28 years back. And
What was your father's certificate?
Nayaka only.
Where is it? Do you have?
No, I have not here, but they have produced that certificate in order to get loans from the societies, farmers societies and all that. They belong to ST only, Nayaka.
But
And this was upheld by the Appellate Authority, that is the Director of Social Welfare, Scheduled Tribes Welfare. That was the Appellate Authority against the caste District Caste Verification Committee. District Caste Verification Committee passed an order that I belong to Parivara, but not to Nayaka. And the Appellate Authority, when I approached the Appellate Authority, that is Director Scheduled Tribes Welfare Department, he declared that I belong to Nayaka only. That particular word Parivara came into existence as an equivalent word, and therefore Constitution of Scheduled Tribes Order 1950 came to be amended in the year 2020. That was a synonym term for the word Nayak. So the synonym terms will take back to the earlier date. If
But
it
how
were to be a,
how can there be a synonym? The castes itself are different.
no, castes are one and the same. Parivara, Beda, Valmiki, all these castes are nothing but Nayaks only. Parivara, Beda, Valmiki, all these castes.
They are classified as Nayaka.
Yes. They are all synonymous to each other.
But tell us one thing, Parivara was not an ST caste. No?
It was, therefore,
It cannot be synonym.
it was a synonym, but it was not included in the ST tribe as a
But
synonym. Synonym.
The benefits or the certification, the caste must be the ST caste.
No.
Only it would be synonym.
Because there was discrepancy, the government of India thought
rectified it.
Rectified it in the year 2020. And that such rectifications will take back to the earlier date. If it were to a new caste.
No, it will take back from that date, back date.
Yes.
How do we get that?
So decisions are there, many decisions are there, my lord.
Sure. See, there is one thing is there. There is no dispute now. Parivara Nayaka now are scheduled tribe caste. ST caste. When we will go? When is at a later date? The argument is sought to be that today they have been made, both have been classified as an ST caste. That's right. This Parivara must relate back to the, from as if it was from the beginning. Is It's an ST, a presidential order under
Yes, yes.
355, 351.
Yes, my lord. Yes, my
341.
lord.
341.
Yes, my lord.
That's a presidential order.
Yes, yes.
It's under constitution.
Yes, constitutional amendment,
2020.
2020, it dates back to its ordinance.
Will that mean it will be only prospective, or will that mean why? See, it's a declaration.
Right, only regarding my submission to your lordship in this matter. The notification or the amendment came into force.
Show us one judgment. It will be prospective, not retrospective. You show
It is-
your judgment.
No such, it is
You
only
show
a
us your
prospective.
judgment. And any presidential order must relate back, or it will have the effect as if it was
Definitely, my lord.
from the year 1950.
Your lordship is perfectly correct in saying.
1950.
50. That is your lordship is perfectly correct in saying.
The appellate order itself speaks that, depending upon one, Gangana versus,
Show us one judgment.
I shall get you the, order
Judgments.
proper, my
There
lord.
are judgments, my lord. I can produce it.
Must relate back,
Apex court judgment.
or
is
it will
there.
have the
Yes,
effect as if it has been issued in the year 1950.
there are
Yes, yes, yes.
apex court judgments are there. I can produce it, my lord.
No, then a single judge goes on the basis, because subsequently this notification has come. Yes, synonymous Nayaka effectively reverting back the presidential order of 19. Reverting back to the.
But here,
It
my
will
lord, it is the-
retroactive angulate the class Nayaka, which is the basis. See, there is some justification for the learner single judge.
Nice.
You see this paragraph, para 10,
Para 10.
para 5, come to para 5.
Yes, madam. The Amendment Act explicitly includes Parivara as a synonym of the Nayaka caste, effectively reverting back to the presidential notification. This inclusion retroactivity validates the petitioner caste status as Nayaka, which was the basis for appointment in 1995. Madam, my submission to your lordship in this matter. He was obtained a certificate, false certificate on the date on which he was obtained 1997. He is not belongs to a Nayaka caste. He belongs to a Parivara. That's why the committee has given a detailed order saying that on the date on which, that too in the year 2019.
Okay, get your judgments, we'll have it tomorrow. Tomorrow. You also.
The day
That
after
is, I
tomorrow.
think, Ram Verma Gijoria case, my lord, where the
The
case
name?
Gijoria, my lord. I have that with me. Ram Gijoria.
Gloria.
Yes, my lord. This is pertaining to caste certificate only, my lord.
No, but is this the?
Similar facts were there, my lord.
True.
Lord, when I was in service bench, my lord, we had referred this judgment, my lord. I can produce it tomorrow. Just.
Page number, kindly, my lord. Kindly look into page number 87 of the file, my lord. There, one order has been mentioned in the High Court of Karnataka itself in the case of Jayanna versus Deputy Commissioner Chitradurga. It has been decided that it has been held that every inclusion as a synonymous caste could have a retrospective effect and would therefore revert back to the presidential notification of 1950. In view of this, the order passed by the District Caste Verification Committee is
Say this.
unsustainable because of the subsequent developments as referred above supra. Accordingly, I passed the following order. They passed that I belong to, that is page number 87. 87 of the file. That is the Appellate Authority's order. That is another order which simultaneously goes with the writ order. Jayanna versus Deputy Commissioner. AR 2012, my lord. AR 2012, KAR 173.
It's not that judgment.
It is not pertains to service matter. It is pertains to land grant matter. Not pertains to service matter.
For
What
service
the learned
matters,
friend
one caste
cited and
for
quoted by the judgment of the, in the appellate order. It is pertains to land grant rules under the PTCL Act, not by a service matter.
whatever the thing, one person, he belongs to only one caste. One for the service matter and one for the revenue matters and all that. He cannot belong to different caste for different purposes. He belongs to only one caste. Whether it is for the revenue matters or for the service matters.
Okay,
Cannot change his caste.
we'll reserve it. Thank you.
Please.
We'll see.
My lord, for that I want to cite some judgments, my lord, if you not permit me.
What is that?
Lord, regarding the obtaining a false certificate
That there is so much of
Not a
law.
false
and also the
certificate.
recent judgment of the full bench in the Bank of India case.
Have not at all produced a false certificate. The question
In a
of
food
producing
corporation
false
case,
certificate does
they have
not
delivered
touch
if
at
it's
all.
food corporation case, your lordship is well aware. In that case, my lord, if it's obtained a false certificate,
Right. Why was this 2020 brought in?
Lord, 2020, my lord, my submission to you, Lord, if you read the notification and other thing, if it is only a prospective in nature, not retrospective in nature.
That's what we
The
are
service
saying.
matters,
We will
that
look
too in a
into it.
service matter.
We will look into it. We will see the law. Okay.
And furthermore, I am outside the service since past more than 7.5 years.
Oh, you have been terminated.
Terminated, my lord, on that count only. There was no fault, even a trace of doubt was not there.
On equity ground, if it's given, obtained a false certificate and you obtained a job, you can't be given a, go by to that. Yes, on the date on which he has not belongs to NICA. That is the verification committee conduct an inquiry, detailed inquiry and pass an order.
Back to the data.
Had I been mentioned that I belong to Parivara, then I should have to be penalized. On the other hand,
Every inclusion of caste or tribe subsequently would have retrospective effect and would have therefore revert back to the presidential notification point.
please, ma'am.
And this is a full bench of this court.
Right, ma'am.
Lord, my submission regarding the land grant matters, your
No,
lordship.
you just note down the citation. Note down the citation.
Yes, my lord.
No, my friend says
This is
that
AIR
one caste for one
2012.
purpose.
2000, that is the thing was cited by the appellate authority.
Karnataka 173.
Your lordship is correct.
No. Just see. What was cited?
There are two judges, my lord, they have given one side. The Justice N.G. Ramesh says that in the notification, if it doesn't says that it retrospectivity, then it can't be taken to relied on the Supreme Court judgment. In that manner, the minority judgment as they said like that, what your lordship referred that one. Subject to correction, my lord.
My lords,
Vikramajit Sen and Jagannath, Justice Jagannath, Justice H.V.G. Ramesh. H.G. Ramesh.
87. What's number one? What's that number?
On the date on which it not comes to notification, 2020, when the judgment was delivered,
A synonym caste, kind submission. A synonym caste will date back to the constitutional original order. If it were to be a new caste, my lord, it could be,
See, that is for the simple reason,
please,
under the Constitution Presidential Order of 1950,
my lord.
under the Constitution, the presidential order was issued in 1950. So anything which comes in must relate back to 1950. That's the intent.
Right, my lord.
Lordships can also refer to. Come go to the judgment. Writ petition number 65002 of 2011. Lordships can refer to this judgment. May I
Just tell us the citation.
please, my lord, WP number 65002 of 2011. This was disposed on 14th September 2020, Dharwad bench. The relevant facts are discussed here also. So far as,
Karnataka High Court only.
yes.
Okay, we will
Says,
reserve
my
it.
lord, that first question that arises for consideration is with regard to prospective or retrospective operation of an act or an amendment to an act. The legal position with regard to the act or amendment thereto being prospective or retrospective is now well settled in paragraph 5.
Okay. And order for reinstatement as well as for paying the consequential benefit. My submission to your lordship, when the before coming to force of the 2020 Act, by that time is already dismissed from service. But
Okay.
the learned judge order for
What is his age today?
Now he is almost 50 plus.
He still have service?
Yes, yes.
Now, what you say on back wages?
back wage, my lord, before Act came into force, what your lordship said regarding 2020, by that time is already dismissed from service on the basis of the cash have obtained a false certificate.
My struggle is that dismissal itself is very much wrong. Kind submission, my lord. The
Okay,
order
reserve.
of dismissal itself is very much wrong to the root.
Okay, thank you.
That's why it should have to be set at right.
Thank you. Reserve.
And thinking of this thing, my lord, learned single judge has passed. With forthwith, it should have to be taken to duty. Forthwith, not time gap has not at all been given.
Reserve, reserve.
Please.
34, number 34.
And for payment of salaries also, one more order is there, my lord.
Payment of
And
salary,
once-
a huge law, this side, that side, both sides. We will look into it.
Podium.
Yes.
I am appealing for the appellant, my lord. The petitioner case is pay protection, my lord.
Please.
He has appointed initially as a lecturer.
Just take those terms.
They say, my lord, in this judgment it is.
Lecturer,
settled.
Yes, from wherever you
They-
working.
They was appointed as in the year of 1983 as a lecturer. The last pay salary was 4,200. After that,
In which organization?
that is education department lecturer.
Hmm.
And after that, 93, the KPSC selection for the scheduled caste community, he was appointed as a deputy superintendent of police. In the year of 93, he was rendered the service 83 to 93 in the education department. The 93, he was not protect his pay scale, that is 4,200. Being
Protect the
agreed
pay
by
scale,
this-
protect the pay scale or the pay.
Pay scale and
You can't seek protection of pay
pay,
scale.
pay, that is 4,200.
Let's see.
Ah,
But were the equivalent scales?
equivalent stage, equal stage. equal
Both education and here.
Yes, yes, yes. I have produced the pay scale also, my lord. That is the appointment pay scale and also it is, and GO is there, the protect the pay. I have produced the GO also. That is the 17th August 1989. page number, that is 86.
Where were you working? In economics, reader,
Is
Karnataka University.
university, my lord.
So.
University.
So it's an employment under the university,
University, my lord.
not under the state government.
No, university, university. My lord.
But your appointment is under the state government.
Yes, my lord, that is.
Will you be entitled to pay protection?
Huh,
The
that is.
employers are different.
No, my lord, the Honorable High Court given the judgment, my lord, in this regard. I have produced the judgment also.
Sure.
That is pertaining to the petitioners, my lord. That is the page number annexure N. That is 99. That is filed by the petitioners. Division bench was given the pay protection and also part service to count the pensionary benefits.
This is Government of India.
My lord, it is Honorable High Court of Karnataka, my lord. The petitioner's case,
Which page you say?
especially page number, that is 99, my lord. That is 99. The Honorable High Court Division Bench rendered the judgment, my lord. That is
Let's
para
see
number
then.
3, para number 3. Since continuity of service is given to the aforementioned officer, petitioner is also entitled for the same respondent shall grant the said benefit to the petitioner in accordance with law and the relevant rules. The fixation of pay shall be made. The filed by the petitioners.
This is for the purpose of continuity of service.
No, and also last sentence, it is fixation of pay also made. They are given the continued service, but not pay protection of the pay scale.
Yeah.
Being agreed by this
Chips may
order.
kindly see page.
What
30.
happened against this order?
Against this order, my lord, he filed an application before the KAT. That is, the KAT is not disposed of the 10 years. Thereby, he agreed this, he filed the application before the SST Commission, National SST Commission. They withdraw the KAT order. The National Commission is confirmed and upheld the petitioners argued and directed to the government to give the pay protections. But they are not implemented. Hence, he filed the application before the Supreme Court. That also disposed. I have produced the order copy also, my lord. This is National Commission order. That is page number 110, annexure R.
Chips may kindly see page 30, my lord. Writ petition it was not
The para
maintained.
number 110, page number. The representation issued from the Dr. T.B. Power, IPS Superintendent of Police, ICT Bangalore, regarding pay protection. Sir, with reference to the subject cited above, his office has received a representation from T.D. Power, which is self-explanatory. The petitioner had stated that he holds the first rank in MA Economics and was appointed under KCSC, Karnataka Civil Service Special Recruitment SCST candidates to certain Group A and B post, Rules 1985. As Deputy Superintendent of Police on 22/1/1993. Prior to his, he was working as a reader in economics at Karnataka University, Dharwad, and his initially basic pay was rupees 4,200. After his selection as DYSP, he was not given pay protection, but this service rendered in KU Dharwad from 21/6/1985 to 21/1/1983 was protected as per the order of the Honorable High Court of Karnataka. They have not implemented. Being agreed by this, he filed the application before the special petition before the Supreme Court. Supreme Court, unable to implement the Honorable High Court, liberty given to the petitioner, once again approached the Honorable High Court. Therefore, he filed an application writ petition before the Honorable High Court, that is impugned order, that is passed by the single judge. Only he has dismissed the writ petition, the withdraw the KAT applications. But he has not go into the Supreme Court order. He is unable to implement the National Commission order, and previously Honorable High Court given the pay protections directions that also not mentioned in the impugned order. That is page number 20,
Page 137.
27, para number 4. The petitioner approached the KAT on 2 occasions before the imputed government order dated 8/1/2004 could be passed. The tribunal on every occasion turned down the claim of the petitioner as he was not entitled to benefit under the Rule 41A of the KCSR. After issuance of the imputed government order dated 8/1/2004, the petitioner again knocked the door of the KAT in application 8/32/2005 and on 10/9/2015 withdraw the said application, and the application was dismissed and withdrawn, after which the petitioner appears to have agitated his grievance before the National Commission of Scheduled Caste, which also declined to accept the claim of the petitioner, after which the petitioner approached the Apex Court, filing petition under Article 32 Constitution of India, which also rejected the claim of the petitioner with the liberty to petitioner approach the jurisdiction of the Honorable High Court under Article 226 of Constitution of India. The order of the Apex Court read as follows. Even on the second call, no one is present on behalf of the petitioner. We are not inclined to entertain this petition under Article 32 of the Constitution. The petition is accordingly dismissed. However, we leave to open to the petitioner to approach the jurisdiction of the Honorable High Court under Article 226 Constitution. We make it clear that we have not expressed any opinion, the merits of the case.
What are the instructions on this? Does the government have any instructions?
Lordships, kindly peruse the endorsement issued by us
Show us.
in page 136 relevant portion, my lord. Second paragraph. 136 page number.
Hmm.
In the case of candidates appointed to the state service by the central government, local bodies, other state governments, aided educational institutions, university service, the service in the previous institution is not the service that can be continued with the appointment in the state civil service. It is not allowed under the Karnataka government service rules to treat such service as a benefit of continued service in the state civil service at any time in any case. Therefore, the current commission's recommendation in the government's opposition so far, not only does the policy provide an opportunity for reopening of certain cases in this regard, but also in cases of recruitment from the central government, state government, autonomous bodies, municipality, etc. There will be a necessity to extend the application to all these categories of employees. The recommendation of National Commission for Scheduled Caste cannot be extended only to the present person, as the proposed action will not only create discrimination among various other categories of employees who are appointed to the state service, but the cases of recruitment of employees of such non-government organization in the current period will flow in flood, and reopen the cases will have a great economic impact on the financial liability of the state. This apart, my lord, the learned single judge has also held.
That's what we are saying. Employers are different.
No, my lord, government GOI is there, my lord. National Commission, GOI is there.
And that cannot
That
be
is, I have
accepted.
produced
That is
the
the
GO also.
endorsement.
First,
Yes, I have GO. That is clearly said that, my lord. Once again, I read the GO guidelines. That is page number 88.
page.
Page 88, my lord, typed copy.
Eighty-eight.
Government of India, that is 7th August 1989. The office memorandum.
1 minute, please. We have not got the page. 88, there's some discrepancy in our paginations.
88, 87, 80.
Let's come to
88 is
page
the GO.
99. 7th August 89.
7th August 1989.
Read
Office,
this, read this.
official memorandum. Subject, guidelines for fixing the pay candidates working in a public sector under the takings, etc. Recommended for appointment by the commission by the method of recruitment by selection regarding.
Minded, this is for the government of India, not for the state government. This is issued for government of India. Now here appointments are under the university and under the state government.
Yes, yes, sir.
Deputy superintendent is not a cadre post, I suppose, in the IPS.
No, my lord, university is not under the government of state, my lord. The university is the central government.
Separate, under a statute.
My lord, in the absence of any government GO, the central government is applicable. There is no GO for the state government.
You can't, very well, we can't say surely. Now you tell us, how is this relevant? How is this relevant? This GO.
I read no. Undersigned directed to pay that as per the extent rules orders on the subject. Pay protection is granted the candidates who are appointed by the method of recruitment by selection through the UPSC. If such candidates are in government service, no such pay protection is granted to candidates working in public sector under the takings. Universities, semi-government institutions, or autonomous body. They said it. When they are so appointed in the government, as a result of this, it has not been possible for government to draw upon the talent these available in non-government organization. Second, the question as to how pay protection can be given in the case of candidate recruitment for public sector undertakings, etc., has been engaging the attention of the government for some time. This matter has been carefully considered, and the President is pleased to decided that in respect of the candidates working in a public sector undertakings, universities, semi-government institution, or autonomous body who are so appointed as direct recruitments or selection through a properly constituted agency, including the department authorities making recruitment directly, their initial pay may be fixed at the stage in the scale of pay attached to the post, so he may and DA as admissible. In the government will protect the pay plus DA already being drawn by them in their parent organization.
What was the scale in the university?
That is 4,200 to 2,200 to 4,200. I have produced the
What is the scale?
scale mallet. In the year of 83 pay scale mallet.
What was the scale in the?
What was he was promoted? Scale. That is appointment order. 2 appointment order. It is annexer A. First.
What is the scale as a DSP?
What is the scale for DYSP? It is 2,200 to 4,070.
4,000?
4,070.
So different scales. Different scales.
Different scales. But last 4,070 is including, the last will be fixed. That is the example given in the GO. He is drawing the 4,200, but at least he entitled 4,070. That is GO he stated, and example also given in this GO.
So it will have a huge repercussion. People coming from university, today is university, tomorrow is another public sector under the state. Everyone will see, give protection. The intent was only this, you are coming from the central government.
No, when is the his part service is counted by the government?
Where, under which?
That is, he also passed the GO. He is admitted to the count service.
Tell us, is the service in the university is being counted for the purpose of continuity? In your case, in the case of this appellant, is the service put in the university is being counted for the purpose of state government service? Tell us, is it yes or no? See, it, at least to our understanding, it could not have been. It cannot be. So you can't draw that analogy. So today you are only seeking pay protection.
We are seeking pay protection and past counting service. That counting service is given to the petitioners.
Have you prayed for that?
Yes, Mala. I have given the application in the representation. I have
service for what purpose?
Pensionary benefits. That was considered.
Is it pensionable university?
That is also pensionable university. Pension, that also.
Is it a pensionable service?
Pensionable service. Direct, it is permanent post.
Did you apply through any proper channel?
Proper channel is recruitment. Also, I have produced the annexer A. It is recruitment.
That?
Annexer A, Mala. Annexer A is the recruitment. Proper channel. It is not temporary.
Ma'am, we should have some instructions on this. We want to look into it. It will have a huge.
Lord, our endorsement is very clear, my lord. They say, my lord, service rendered in any.
What is the basis for that endorsement? You may say so.
For a
but
moment.
You have to.
My lord, for a moment, your lordships may kindly peruse page 135 also. Paragraph 2, my lord, they have quoted the KCSR rules also, my lord, here. Paragraph 2, my lord. 135.
Yes.
Service rendered in aided other government, autonomous body, etc. is not a service rendered in service under state government. These are two separate services. date 1/4/2006 only in recruitment cases prior to other government or non-government aided institution, university, only to be considered for other fatal service as special inclusion only for the purpose of superannuation benefits as per KCSR rule 235, 235A, B and 248. In the case of university employees who are in service of university prior to date 1/4/2006 and are appointed in government service prior to 1/4/2006, such service shall be deemed to be added to the existing service as additional service under rule 235. Appointment from one department or service under the state government to another department or service under the state government can be treated as continued service under the government only if the appointment is made in accordance with the rules and may be considered for pay protection under these rules. Karnataka government service rules are not directly applicable to all these categories of employees. Prior service shall be considered as additional service subject to the limitation of special facilities provided in the annexure, as the service rendered earlier in the university is not allowed to be treated as continued service under the government. The salary received earlier is not allowed. And this apart, if my lords may kindly see the order passed by learned single judge, they have withdrawn their application before KAT. They have withdrawn their application before KAT. That is what the learned single judge says. Therefore, the challenge to the government order dated 8/1/2004 ended in its withdrawal. It is tried law with that withdrawal of the petition without liberty to file a fresh petition would amount to dismissal of the consent. More so when liberty to file a fresh petition is sought in the light of the law laid down in so and so. The petitioners having withdrawn his claim before KAT way back in 2005 and not having agitated the same all along cannot now file a writ petition challenging the order passed.
How would you answer this? How would you answer having withdrawn your application?
My lord, during pendency of my application challenging the 2004 order before the KAT, the 10 years it was pending. That's why I approached the National Commission. The two proceedings are not simultaneously going on. That's why I'm withdraw the KAT order.
But the challenge is
Only that reason.
What is the effect of withdrawal?
The National Commission was consider my representation directed to the government to consider the representation of the petitioner according to the GO and give the benefits and pay protection. I have produced the National Commission order.
So what happened thereafter?
That was not implemented by the government. He has given undertaking before the National Commission. I have produced the order of the state government. He has given undertaking but not implemented. That's why I approached the Supreme Court. But Supreme Court given liberty to the once again approach the Honorable High Court. His total grievance.
is governed by KCSR rules, 235.
Show us.
Yes, ma'am. Specifically, deals with pensions, where it says
Counting for part service, 235. That is considered by the state government 235. There is no grievance.
But my lord, how could this when my lord he has withdrawn his application before KAT, he has no that withdrawal was with the liberty to file fresh petition, my lord. They could have filed a fresh petition after the the decision taken by the National Commission.
Which is the provision, ma'am?
235, my lord. That is what the ACSR.
235 KCSR. 235.
235.
And according to this section, the state government is considered his past service. 235(1).
How is this relevant?
Relevant, my lord. 235, under the 235, the past service
They
was
say,
counted. Only regarding pay protection. When the service was counted by the state government, he bound to give the pay protection.
The endorsement also says that, my lord, those who were appointed prior to 1/4/2006. Such service shall be deemed to be added to the existing service as an additional service.
That's
under
why it
rule-
is added.
Under Rule
That's-
235.
That's why it is added. He is appointed in the 88.
How do they overcome this order of the learned single judgment? The endorsement also says, my lord, the recruitment of employees of such non-governmental organization in current period will flow in flood and reopen the cases which will have a great economic impact.
We'll continue. I
At
think we'll
certain
look into
conditions
it.
in 235, my lord.
Just say we have heard the counsel for the parties for some time to come up for further arguments along. Just check what law you have.
The division bench also, it is clearly directed to the respondents to consider his pay protection and also given the render the service to pass to the pensionary benefit. Already he is considered the part service, but not given pay protection. It is against
First
the,
take
it is this
instruction.
Karnataka State Government Honorable High Court judgment.
You have to
That is
look
why
into-
annexed.
You have to look into the division bench judgment.
Division bench judgment is covered, my lord.
About
Already this
particulars of
matter was discussed, my lord.
Okay, thank you.
Annexurian, my lord.
Next.
2nd of April.
What is this, Mr. Shetty?
This is with regard to promotion, my lord. The first respondent, my lord, was appointed in the year 2006. And he has been working as a ASO, that is grade A, my lord, Assistant Security Officer A. The second respondent has been promoted, my lord, on the basis of his unit-based vacancy in the year 2020, my lord, to the next post, my lord, that is ASO B, my lord. That higher responsibilities there after 5 years of minimum service, my lord. But in the unit of this first respondent, my lord, there was no vacancy because it is unit-based promotion. So later, my lord, in the year 2021, the first respondent, second respondent got the SO post, my lord. By considering combined experience of ASOA plus ASOB for 8 years experience. That is what this notification provides for. So now, my lord, they have first respondent challenged it, my lord, on the ground that he is a senior to the second respondent. He has not been granted promotion. Now, my lord, as per the impugned order, my lord, in page 45 and 46. Now the notification so far as providing for that provision, my lord, combined experience of 8 years, ASOA plus ASOB has been, that provision has been quashed. Now the petitioners have been directed to conduct a review of DPC, my lord, to consider the case of the first respondent. Now, as on this day, there is no notification, but they have quashed it. They have already quashed, my lord. Now, if that 2012 notification, my lord, all this,
We'll issue notice, let them
please,
come.
they have filed a contempt petition.
When is the date?
Date next date, no, the 17th it was there, my lord. Now,
What is the next date?
next date I will ascertain.
Just serve them,
Please,
issue notice, next. Both 35, 36.
please. If interim order, my lord, in contempt is there, my lord, I will.
No, what is the date we want to know?
Please, I will leave.
Next.
22-4. 37 adjourned. 38, Shri Gauram. Shri number 38.
Yes.
And for the respondent. Appeal is against an arbitral award passed in the year 2000.
Just show, was anyone present on the last date? Their challenge has been rejected.
The challenge has been rejected under section 34.
Say none for the appellant. In the interest of justice, re-notify. Liberty shall be with the counsels for the parties to file written submissions.
Yes. That since it is an appeal under section 37, if a direction would be given by them, to them to submit their written submission first, accordingly, I will reply to that. That will make it more comfortable even for me to argue.
You file separately. Next, ma'am.
25-6. 39 and 40 adjourned. 41, Shri Venkatesh. 41.
The respondent, my lords, they have filed an objection, application for withdrawal, my lords, and the objections has been filed, my lords. That's a date may be fixed for hearing, my lords. Next date of it.
Lord, regarding, my lord, withdrawal of the amount is concerned, I filed detailed objection, my lord, on the ground that, my lord, they have filed 2 CMP. In the first CMP, my lord, we have disputed very basis of the, my lord, execution of the MO, my lord, 13/11/2013 on the ground that there is a forged document. My lord, it is referred to FSL. FSL report received by this court, my lord, holding that, my lord, the document was forged, means mine document was forged. But during pendency of the first CMP, in the first CMP, my lord, they have invoked, my lord, the arbitration clause found in the MOU. When the CMP is pending, my lord, another CMP is filed to invoke, my lord, partnership firm. Where, my lord, I have no option since both parties are binding on the agreement, my lord, the arbitration agreement, it is allowed and referred to, my lord, arbitration. My lord, in an arbitration, the document which was subject matter, my lord, in earlier CMP, which was, my lord, disputed by me, my lord, is a forged document. The same document was produced before the, my lord, arbitrator, and he obtained, my lord, export award. In fact, my lord, the award was passed during, my lord, COVID. Since I was shifted my residence from Bengaluru to, my lord, my native place, Andhra. So no notice was served. Even, my lord, even arbitration, my lord, the notice was served. In fact, I was placed ex parte. Thereafter, my lord, they took paper publication. Even then, my lord, it was served and the ex parte award was taken. So on that ground, my lord, I have detailed, my lord, filed my objection saying that withdrawal of amount is not permitted. Well, I'm ready to address, my lord, argument on the main, my lord. If the date is fixed, my lord, I'm ready to assist the court.
At the request of counsel for the respondents. Respondent number 1,
Yes, my lord.
adjourn to.
24-6,
24/6, much.
42. Deepak Diya. 42.
Giving the response, my lord, very short adjournment, my lords.
No, my lords, my lords, what has happened is,
My lords, we are ready for arguments, my lords. Kindly give a short explanation.
Yes. Hello, you are for the appellant.
yes, I am for the appellant. In this case, last time, the court had directed the respondents to file the application form of the IMA Hubli, in which I am a resident of Bangalore. And today a copy was served to
My
me.
lords, we have filed the, no,
My
my
lords,
lords, on 21st only we
what
have
has
served
happened is, my
copy
lords,
as well and we have filed it.
the application form may kindly be looked into.
How is the jurisdiction determined?
My lords, jurisdiction determined is not being mentioned in the application form. And the application form may
My
kindly be
lords,
looked into,
in
my
the,
lords.
in the
May kindly be
application,
looked
is
into, my
the
lords.
clause
And
where
our
it's mentioned.
interim,
Ma'am, just 1 minute, please. Just 1 minute.
my lords,
Yes.
the application may kindly be looked into, my lords. I have filed it on 24/1/2025 memo. Memo dated 24/1/2025.
It's not here.
My lords, the application copy,
Now tell us,
Yes,
what
my
is the
lords.
ground on which the lower court has rejected it?
my lords, order 7 rule 10 CPC read with section 2, that it does not fall under the commercial court because the transaction between the
Shows the CPC.
appellant as well as the IMA Hubli does not fall under the commercial transaction. That is the contention what they have taken. I may be permitted to take this honorable court to the judgment at ink page number 20, my lords, 20, 21, 22. They say that this is not carrying a my lords.
What was the nature of suit?
The suit, commercial suit was the recovery of money, my lords. Recovery of the policy money, what I had to receive, because the policy was taken by my husband, who demised at the time of COVID situation. And he was a medical doctor by profession. The 2 social security schemes which were being introduced by the respondents, my lords, is pertaining to the benefit to be given for those medical doctors for their permanent disability as well as death. And as the death happened due to COVID pneumonia, and I had to submit my insurance papers because I am the wife, and the nomination was given to my wife as well as the 2 children. two nominees in each social security scheme, my lords. In one social security scheme, my wife and my first daughter, or my daughter, was made as a nominee. And in the second social security scheme, my wife and my son was made as a nominee. And as we were nominee holders, we produced these insurance policy certificates telling that this is the money what we had to get. And at that point of time, IMA Hubli had circulated a resolution also telling that 3 times the money will be given to the policy holders for the person who goes for the death scheme. So unfortunately, what happened, this person, that is Subraju, he died out of COVID pneumonia. We have produced all the medical certificates and all those things, and almost all the other doctors were given the benefit, but my particular
So an insurance scheme
yes, my lords.
or a claim thereunder would not be a commercial dispute.
That is their contention, but I fall under section 2, subclause 1, 20, my lords.
They show the commercial codes.
I fall under section 2, subclause 1, 20, my lords. Section 2, subclause 1, subclause C, 20.
Yes.
Insurance and reassurance. So I fall under this particular scheme, my lords.
What is the finding on this?
My lords, the finding given by the lower court is telling that the application IA number 1 filed by the defendant under Order 7, Rule 10 and Section 9 and Section 151 CPC read with Section 2(1)(c) of the Commercial Courts Act is hereby allowed. So my at the preliminary stage itself, the commercial suit was dismissed, but with the reason that the plaintiff is directed to receive the plaint and present the same before the appropriate court at Hubli within 10 days. My lords, I am a widow. The whole transaction has happened from Bangalore, and the application form also clearly discloses it is from Bangalore. And it has been mentioned in the application form that I belong to IMA Bangalore. My lords, may kindly be permitted to see the application form, my lords. In this, it is clearly stated, motivated IMA Dr. Life member of Bangalore branch to become member of IMA. So he is the person who has.
Now you are claiming the relief against 1 or 2.
Actually, first social security scheme is belonging to respondent 1. Second social security scheme is belonging to respondent number 2. But the address for service is actually the same as respondent number 1. The IMA Hubli has got 2 wings in the same address.
You are a member under the IMA? You are a member?
Yes, my lord. I'm a Bangalore.
The scheme is floated by the IMA?
Yes, my lords.
Now, what does the jurisdictional aspect of the bylaws of IMA say?
My lords, the bylaws of IMA clearly say that the jurisdictional aspect falls to the jurisdiction of Hubli.
If that be so.
Yes, my lords. But this bylaw was not circulated to me and it was not even informed. But IMA Bangalore is the membership what I hold. And
May be right.
yes, my lords.
But still in terms, see, you would be governed by those bylaws
Yes, my lords.
of the IMA.
Yes, I'm very much like.
IMA bylaw says the jurisdiction would be.
But I was never intimated regarding this bylaw. Bylaws were not circulated to us.
My lords,
You are expected to know your membership.
my lords, in the application form.
Yes, 1 minute, ma'am. Your membership is under the bylaws.
Yes, my lords.
The IMA.
It is definitely under the bylaws.
So how would you answer that?
My lords, at that point of time when the scheme was opened and at that point of time COVID was also there. My lords, immediately after the demise of my husband, as a family, I did not have any, I was not in a position to even to look into these things. But immediately when we filed an application, they did not reject the application on this particular. They rejected the application telling that you have produced a false medical certificate. IMA.
Today, when matter went before the court.
Yes, my lords.
The court has invoked that, saying that it would be the Hubli jurisdiction because of the bylaws, because of what the parties have decided.
But one thing is, my lords, actually, considering the bylaw also, the jurisdiction part, my lords, may kindly be looked into, my lords. In the,
Which page?
my lords, additional documents, ink page number 37. I have filed my additional documents, my lords. I have filed the additional documents, ink page number 37 of the additional documents, my lords. That is the bylaw copy, what I got it from the website. Clause number 12, jurisdiction.
When did you file it?
My lords, I filed it on my lords, I filed it on 13th June 2024.
Which page is this?
Ink page number 37, my lords.
Yes.
My lords, clause number 12 may kindly be looked into. Jurisdiction of the operation of the society extends all over the Karnataka state territory. The legal jurisdiction of the society is at Hubli.
So how would you answer this?
My lords, particularly to this particular point, my lords, bylaws were not at all circulated to us.
Doesn't make any difference. You are
Much
expected.
obliged.
See, the membership is under
Yes, my
bylaws.
lords. But what has happened is, my lords, I am a widow, and my entire transaction happened from Bangalore.
Right. Will that be a relevant consideration?
My lords, I
Parties-
produced one judgment of the.
Parties are bound by these.
My lords, I had produced one judgment of the Honorable High Court, my lords, what was being decided on the same point of jurisdiction. My lords, I may be permitted to.
Two places have jurisdiction, but parties decided to confine to one. Valid.
But going to Hubli, my lords, it will be very,
That's it.
because I am a widow, because at that point of time,
Can that argument be hold good?
no,
So
it
tell
will,
us
it will not, it will not.
then. Think over it. Getting the point.
But this is the one judgment what I had placed before the lower court also regarding territorial jurisdiction, my lords.
See, this law is well settled.
Was reported in 2012 AR, my lords.
Has the learned judge returned the plaint on this ground?
Yes, my lords. It has been returned on this particular ground only. My lords, it is pertaining to a hire purchase agreement, territorial jurisdiction, wherein the vehicle forcibly taken back by the hirer sued for mandatory injunction by the purchaser directing defendant to release the vehicle and restraining it from alienating that vehicle. Defendant having its branch office at Bangalore, contract was entered into at Bangalore and vehicle was registered at Bangalore, which was also seized by the defendant at Bangalore, held competent court at Bangalore would have jurisdiction in respect of the cause of action merely because in an agreement parties have confirmed jurisdiction on some other court is immaterial.
That some other court would also have a jurisdiction?
Yes, my lords, it will have.
You check up the Supreme Court judgments.
I will.
That law is settled.
Yes, my lords, regarding jurisdiction, I do admit, my lords, but as I am a widow,
Some other court is immaterial.
my lords, I don't know anyone in Hubli, my lords. And one more thing is on this point of in the initial threshold itself, my case was dismissed by telling that return of the plaint.
Obviously, that's the better way now, so that you can work
My
out.
lords,
your
and also the time given was 10 days, my lords, for me to go and submit the.
How much time you want, tell us. But
At least one-
see, you have to see the law also. Once the plaint is returned, when are you required to present it?
Yes, my
The
lords.
point.
But at that point of time, my lords, I did not have any other option to come before this honorable court because
So
I
just-
felt that jurisdiction was not explained to me. and a certificate was given to me in Bangalore. And all the other formalities were also done in Bangalore. But I never expected that in the bylaw, as a party, I did not know, my lords.
Right. Possibly, they want that rather than having jurisdiction or giving jurisdiction or every place wherever the membership is, signed or wherever the member resides, to have it at one place. Maybe that.
My lords, even in the legal notice, what we sent, reply notice also, they did not take jurisdiction as a point.
They will not take it there. They will take it in the court. The court's jurisdiction. So you just think over it. When do you want?
Any short date may be given, my lords. I will ask the party and I will come back before this.
We have heard the learner counsel for the appellant and the respondent to enable the counsel for the appellant take instructions. When do you want?
My lords, by next week, my lords.
Next week. Just give it that April.
8/4.
Much obliged.
Just say that we have been informed in that matter, ma'am, where he appeared for 34, 35? 35, 30. We have been informed by Mr. Shetty that the respondents have filed the contempt petition. If that be so, on a mentioning made by Mr. Shetty before the tribunal for adjourning the proceeding beyond the date fixed by this court. In this writ petitions, the tribunal shall adjourn the same to a date beyond the date fixed by this court in this proceedings. Okay? Just make a request.
Page 43.
Which respondent had filed, Mr. Shetty? Just 1 minute, Mr. Naganan. Which respondent has filed the contempt?
First respondent.
In all the three, in
In
all the two?
Two, my lord.
Respondent number 1. Okay. Yes, Mr. Naganan.
Lord, I appear for the appellants, my lord, in all these matters. We are, my lord, the electricity company, KPTCL. The dispute, my lord, relates to the question relating to 3 sets of employees: assistant engineer, junior engineer, and lineman or gangman. They were all, my lord, employed on a contract or temporary basis prior to 1/4/2006. That relevant date, my lord, is that the new pension scheme came into force on 1/4/2006. The central government, my lord, had notified it in 2004, but state, my lord, adopted it in 2006. So when they were appointed, my lord, there was a letter of appointment given. There was an agreement that was entered into which specifically said they are governed by the new pension scheme, because their regularization admittedly happened after 1/4/2006. For about 9-10 years, my lord, they kept quiet. They continued to contribute, and it went on. Then they gave some
under the new scheme.
Yes, new scheme, contributory pension scheme. They
But
continued.
this new scheme is still in vogue.
Yes, yes.
But in 1 or 2 states, I think they have shifted to the old scheme.
The central government now, my lord, is having some rethinking on that. And so therefore, the states, my lord, they find that this is causing a little less burden for the state, in the sense that just like every other contributory pension scheme, the employee deduction some amount, like provident fund, etc. And some portion the government contributes. And with the longevity, my lord, increasing now, in the past, my lord, 70 years was like the real limit. Not many people actually survive beyond that. But today, my lord, we see 80, 90-year-old people, my lord, are quite hale and hearty. So if you effectively work for 30 years.
Knowing, that 1486 CPF to pension scheme, the shifting after 4th pay commission, a huge litigation. And you would not imagine, we are talking of 86, still there is a litigation.
Exactly.
Where people wants to shift from CPF to, the pension scheme. More beneficial, you have pay commissions coming.
And another thing is, my lord, that it is open-ended, in the sense that as long as God gives you life, you are going to continue to receive.
After 80 years, there is something, I think you get something
Extra. And therefore, my lord, that is certainly more beneficial. But states, my lord, today they are spending something like about 60 to 65% of the entire budget of the state is spent on salaries and employment and perquisites to employees, including members of legislative assemblies, who have recently been given a very hefty hike as per the newspaper reports, doubling everything.
They are entitled to pension?
Yes, they're entitled to pension also. Salaries have been doubled, pension has been increased substantially, and the MLA's salary has been doubled, perquisites have been increased. So I read in the newspaper, it's going to cost the state nearly 100 crores a year. And that will have a cascading effect so far as pensions are concerned. So that's the reason why the central government, my lord, because of fiscal prudence, they said that you must encourage people to contribute something, and the state will also contribute. It's not the state will not contribute.
Based on their contribution would be the output,
Exactly.
what to be given.
But the end date is being uncertain. Therefore, an actuarial assessment has to be made. My lord. Even for gratuity and other things, when the trusts are set up, they make an actuarial assessment to say if you have 500 workers, how many of them are likely to not complete their tenure, how many will retire on what date, how many may leave. All these assessments are done and they arrive at a figure of what should be contributed to the gratuity fund every year. That's so much the actuarial assessment is made. Same thing happens with pensions also. But since it is government, unlike a commercial entity, my lord, which will have to make it and keep aside the money and provide in the books, in the case of government, my lord, they don't follow this double entry system of accounting, nor do they prepare a balance sheet like what companies prepare. So on a particular date, if you draw the balance and ask, what is it that the state has and what is it that it owes, that is not available. In fact, there is a move, my lord, the Institute of Chartered Accountants is impressing on the government to move to a balance sheet mode. Because today, my lord, in the budgets, if you see, you'll only get total in receipts, total expenditure. Assets are not forthcoming anywhere. So we don't know whether a country or a state is a negative net worth or positive net worth. So that is a problem. So, my lord, in this case, what happened was those who they were employed in a temporary capacity, either on a contract or probation, they were given regular appointment after 1/4/2006. And for 7-8 years, my lord, nobody objected. Thereafter, they started giving representations to say that, we should also be entitled to this benefit because our initial employment started earlier. And those were considered, and they were not after due consideration. The board, we are a limited company, my lord, under Companies Act. We are not a board or a statutory body. The board decided that this cannot be extended to them, and that is what was challenged in 2015. The scheme came in 2006, and 2015 the writ petition was filed. And there, my lord, they don't question their own agreements. They entered into agreements. There's a board orders. None of those are questioned. But they question the last rejection of their representation. The learned single judge has been pleased to allow the writ petition, my lord, holding that since they were employed in some capacity prior to 1/4/2006, the new pension scheme cannot be applied to them. They will be governed by the old pension scheme. So there's a direction to refund whatever they have contributed.
And tell us one thing, when did at least to my recollection, there are judgments, possibly you must have seen it, any recruitment which has been initiated before 1/4/2006.
Yeah.
Initiated. And possibly, I'm going a step further, that a merit has been drawn. Effectively, the appointment letter was post 1/4/2006. I think it appears there are judgments to say that give the benefit of the old scheme.
Yes, that's transition, my lord, I would say.
That's transition.
Transition, I understand. Because the process has started, advertisement is issued, everything is done, and they have shortlisted everything. It's only a question of physically giving them a letter and giving a date for joining. There, the transition, I understand. But here, my lord,
temporary status, the temporary status may not necessarily lead to a regular appointment.
Exactly. Yes.
It would still be you are till as temporary status till such time you get regularized under the relevant rules.
A regular recruitment. Yes.
Regular recruitment.
Now, in these cases, it was 1 year, my lord, appointment was given. In many cases, they have been continued after 1 year. Initial 1 year, thereafter they have been continued in the same position on a contract basis. Till they decided that now they formulated a separate scheme and then said, okay, after this date, we're going to regularize you, appoint you in a regular post. So that is a short point, my lord, which will arise.
I think we have to only see the judgments only. But here, no, let's see the finding of the learned judge.
Yes, ma'am. If your lordships could take 1240. 43.1, I think, not is there in the listing.
Let's see that.
The discussion, my lord, begins after noticing the contentions. Now, please go to page number, I can give your lordships the internal page 37 or serial page 67 in this case, 1240. Para number 21. Having heard the land counsel appearing for the parties, it's not in dispute that the petitioners in the above writ petition were appointed by the erstwhile respondent board. Thereafter, their service has been regularized. Petitioners are appointed against substantive post in the respondent board. Therefore, for all benefits and conditions of service, petitioners are on par with the employees who were appointed prior to 1/4/2006. This may not be factually correct, but I'll make submissions. It is to be noted that though these employees were appointed as against substantive posts, Respondent Corporation has implemented the new defined contributory pension scheme introduced on 1/4/2006, not as per existing pension rules as on the date of entry into service. The conditions of qualifying service to the employees is governed by the Karnataka Electricity Board Employees Service Regulations passed by the erstwhile Respondent Board as per Section 79C of the Electric Supply Act of 48. Chapter 9 of said regulations provides for pension regulation, which reads as under. 169. The gratuity, pension, and the death cum retirement gratuities, including family pensions payable under these regulations, are debitable to the Karnataka Electricity Board Employees Pension Fund, to which a contribution equal to 1/8 of the pay of the employees or such other rate as may be fixed by the board from time to time is made annually by debit to revenue. This may not in the old avatar, and it was board and not company. Cases where pension is inadmissible. 174. In the following cases, no claim to pension is admitted when employee is appointed for limited time only or for a specified duty on the completion of which he is to be discharged. When a person's whole time is not retained for the corporation service but merely paid for work done for the board. When an employee serves under a covenant which contains no stipulation regarding pension, unless the board specifically authorizes the employee to count such service towards pension. Or in this case, there is a specific covenant which says that you will be governed by the new pension scheme. It is also pertinent
Where?
in the appointment letter, my lord, on regularization. In that appointment letter itself, it says that you are going to be governed by the new pension scheme. And they accepted it, my lord, from 2006 onward without demur till.
What happened to those employees who retired in the interim between 6 and 15 or 6 and 16?
My lord, this association is before our lordships along with some individuals. So probably they will, whoever is agitating is before the court, and whoever is retired or not.
They may come.
They may
later
come,
if
yeah.
they succeed.
Yeah.
Okay. But they have been retired under the new pension scheme.
Exactly. Yes. And they are getting pension under the new pension
New
scheme
pension
only. Then, my lord, the next regulation which the learned judge refers to, I'll skip over what is not directly relevant, my lord. Please go to page 69, the regulation number 179. The service of an employee does not qualify for pension unless it conforms to the following conditions. First, the service must be under the corporation. Second, it must be pensionable establishment. For determining title to the benefits on death in service fund, so the following is to be reckoned. Then the first, service of an employee is deemed to have been under board if he is appointed and his duties and pay are regulated by the board or under conditions determined by the board, provided that the service rendered by an employee under the state government prior to the constitution of the corporation shall be regarded as service under the board. In case of an employee temporarily serving under the state or central government or in forest service, his duties and pay during the period are deemed to be regulated by the conditions determined by the board. So that means there was flexibility there. Second condition, service of an employee does not qualify unless the employee holds a post permanent or temporary on a pensionable establishment under the board or would have held such post but for his temporary transfer outside the board service. Temporary post includes a post held in officiating basis. Service in non-pensionable establishment like establishment paid out a contingency, etc., will not qualify for pension and these regulations In respect of an employee's monthly rated retirement or death while in service, all service under the board, whether temporary or permanent, shall count. The board may, by general or special order, permit non-pensionable service for performing which an employee is paid from the board fund to be treated as service qualifying for pension in issuing such an order. The board may specify the method by which the period of qualifying service shall be calculated, may be imposed any condition which it thinks fit. Then, my lord, 2. Employees born on TTR establishment of the board subsequently absorbed permanently to the pensionable establishment and the board are entitled to count 1/4 of their service in TTR establishment, subject to a maximum of 3 years for purpose of pensionary benefits. Wherever pensionable service and the corporation has been rendered in continuation of service in the government, local body, district board, municipalities, former railways, Mysore at Hyderabad, central government, state commercial concerns, or autonomous bodies of organizations set up by government or the state government, service rendered in such institutions shall count as qualifying service for pension, subject to the following. Where service rendered under the institutions referred to above is covered by the contributory pension provident fund scheme, and the contribution of such institution with interest has been drawn by the employee, the amount so drawn shall be credited to corporation with interest at 3% per annum for the period from the date of drawing the contribution to the date of credit. These are all not transitory. If he is employed somewhere, he comes here, what happens to the PF? Then not, please go to next page, para 23. Having taken note of the conditions of service as mentioned above, particularly note to resolution 181(1), the respondent corporation has introduced new defined contributory pension scheme as per order dated 5/7/2007. It is categorically stated in the order the suitable amendments be made to KEB ESR separately. In the background of these aspects, is not in dispute that the respondent corporation has submitted and produced the documents to establish that amendment has been made, but the same was not published in the official gazette nor made known to the general public, particularly the employees concerned. Therefore, I find force in the submission made by the Learned Counsel appearing for petitioners, and the amendment said to have been notified by respondent corporation to erstwhile KEB employee service regulations is void, cannot be made applicable to petitioners herein. This, my lord, I submit is very far-fetched. Can't be so. Because earlier, there's no requirement of gazetting it. It's a corporation, it's a company. And they had adopted the terms and conditions of the erstwhile board. Now, after that happens, there is no provision for the company to publish anything in the gazette. They made their policy, they amended that regulation which was there. Now, learned judge seems to think, my lord, that that can only be done by means of a gazette publication. And for that reason, learned judge says that that amendment is void, but there's no challenge to the amendment. The prayers, my lord. And my lord, I've also we have taken a stand and pointed out to the learned judge that we put all these amendments in the website. We publish a booklet. This employees association is aware of it. And my lord, it's difficult for anybody to believe that an employees association with so many office bearers and thousands of employees, the gangmen are some 7,000 of them. All of them were completely ignorant of this, of the amendment made, and they participated in the new pension scheme, and every month the deduction was being made, and they never thought anything was wrong, and not questioning anything. That, my lord, is a bit too far-fetched, is my very respectful submission. Nextly, similar employees of the postal department have challenged the implementation of the new pensionary benefit to a central administrative tribunal, and the tribunal allowing the original application being agreed with the same postal department filed writ petition, division bench of this court by order dated so-and-so has held as follows. Secondly, the issue whether such persons would be considered under the old pension scheme or new one is no more res integra, as the same issue had arisen before the Learned Central Administrative Tribunal, Jaipur, and the Learned Central Administrative Tribunal, Mumbai, even in the case of Union of India versus Vijay Kumar before the Honorable Delhi High Court in WP number so-and-so. The scheme in these cases were similar to the present scheme. After taking a holistic view of the decision of the Learned Central Administrative Tribunal, Jaipur, Learned Central Administrative Tribunal, Mumbai, and the decision of Rajasthan High Court, their lordships of the Delhi High Court was of the opinion that those employees who had been granted temporary status prior to coming into force of the new pension rules, those employees were given the benefit of general provident fund under the old pensionary rules. These employees who had been given the benefit of having their period of temporary service counted for pensionary benefits, they were certainly entitled to be covered by the CCS pension rules of 72. They would not be governed by the new
Yes.
pension scheme of two.
Now, this you have seen. Under the temporary service rules, there is a stipulation 50% of the service as a temporary survey would be counted for the purpose. of
Exactly.
term. Now, in this case, all had the temporary status.
All temporary only. All of them, Lord, who are involved in the writ petitions, they all are appointed on temporary basis.
No, temporary status is one, temporary service is one. Temporary service, so what we say, it's not permanent.
Yes.
According to you, it's not permanent. They were not given any different status under any scheme of the government. They were temporary, not permanent. That's what you want to convey.
Yes. And they were given a fixed remuneration.
Fixed remuneration, not on the basis of scale,
Scale.
no casual leave, no.
No.
Because under the scheme of DOPT,
May I read that appointment letter, my lord, one of them? Yes. Your lordship will
because
find.
why we say that judgment of being referred.
Yeah.
It has actually gone till the Supreme Court. Supreme Court says, and that it appears to have interpreted that to mean when 50% of the temporary service is counted and you have been given the temporary status, it necessarily follows that need to be counted to the pension.
For all
Which
other
pen-
benefits.
Which pension means pre-1 4.
But here, my lord, they say that you are governed by the new pension scheme at the time itself.
No, we just wanted to know, was it a temporary status under any scheme or he was only a temporary employee,
He was simply a temporary employee.
not a permanent employee? Oh,
Your lordship may permit me to read just one appointment letter, my lord. At page 179, there is an agreement and appointment letter is like. Kindly take, my lord, 179, there is an agreement. Or at 178, my lord, first. Page 178, annexure H.
yes.
This is a pro forma given to all of them. 34/2007. Mr. So-and-so, appointment to the post of Assistant Engineer Electrical on permanent basis, employment number, decision so-and-so. You are appointed as Assistant Engineer on contract basis against notification number so-and-so in KPTCL and working in 110 MUSS so-and-so. Considering our service as contract assistant engineer, KPTCL is pleased to appoint you on a permanent basis in the time scale of so-and-so with effect from the date of this appointment order on the terms and conditions detailed in the enclosed annexure. Your appointment will be against the post in which you are presently working on as is varies basis. However, KPTCL ESCOM reserves the right to change the place at its discretion. Your service on contract basis shall not count for any purpose, including for fixing salary, seniority, promotion, or pension. Your seniority on permanent appointment to the post of assistant engineer will be fixed provisionally below the last permanent assistant engineer electrical working in KPTCL or in respect to ESCOM on deputation. In other words, existing permanent assistant engineers electrical working either in KPTCL or ESCOMs will be seniors to you at all times. Your final seniority as assistant engineer will be fixed in the course of time as matter relating to exercise of option by officers is pending decision before the Honorable High Court of Karnataka. You are not entitled to the pension as per existing pension rules. However, you will be covered under the contributory pension scheme, which is under consideration for adoption by KPTCL with effect from 1/4/2006. Then, my lord, other 2 hours. Then kindly go to the next page. When he was appointed, what was the documentation? That's page 179. Annexure J.
There is agreement is also signed. It's a formal agreement.
It's a formal agreement.
The appointment order doesn't really govern the relationship.
It does, but my lord, they followed this procedure. Probably this was a transition stage between board and company. So they thought we must have a formal agreement. So that's how, my lord. This is signed. Service conditions, my lord, at page 180, they refer to the old regulations of 1987. And it also says as amended from time to time. This is, my lord, at the time when they were appointed. And probation. Now, my lord, please see what was the documentation they first engaged. That's, my lord, at page 141. Annexure B. Appointment on contract as contract assistant engineer in KPTCL. Notification so and so. Pursuant to your application number so and so, in response to notification cited above, the company is pleased to appoint you on contract as contract assistant engineer on a consolidated remuneration of rupees 8,000 per month. Your contractual employment will be governed by the terms of appointment as laid down in the annexure to this appointment letter. You have been posted to work in the following office and with instructions to report at the place on the forenoon of 5th. If you fail to report prescribed date, you shall be deemed to have not interested. You may sign a copy of this letter. Then, my lord, at page 142, your lordships will see how the board looked at it at that point in 2007. This is the board resolution, annexure C, page 142. The relevant portion, my lord, is at 143. The bottom of 143, my lord, subject 59/08. Appointing and regularization, that's how it reads. In page 143.
Yes.
The board was appraised as follows. In order to overcome the severe shortage of staff at the cutting edge level, 830 contract assistant engineers electrical and 385 contract junior engineers electrical were recruited during 2003-04 in KPTCL and ESCOMs for a period of 1 year, extendable up to 3 years on a consolidated monthly remuneration to 8,000 and 5,000 respectively, against employment notification dated 7/5/2003, duly following due recruitment process and reservation policies of government. They were not recruited directly in order to have the candidates who are willing to work in fields in sincerity and dedication. The contract of these engineers has been renewed from time to time. They are working as in KPTCL ESCOMs. Their work has been satisfactory in most cases. They have been working well. Board finds that they have good talent and experience of working in the field. Now it's not desirable to dispense with their services. Since the above contract engineers are working for more than 3 years, and in order to make the above engineers more accountable and to entrust additional various responsibility as regular post of assistant engineer, it is proposed to appoint them on permanent basis with prospective effect. KPTCL has scrupulously observed all conditions of appointment prescribed in the KEB regulations, vis-a-vis qualifications, age limit, cutoff marks, even though the appointments are on contract basis. Further, they have been appointed through a transparent selection process involving calling of applications through newspaper advertisement, conducting special technical aptitude tests, and considering the academic marks. Government guidelines on reservations in recruitment have been followed scrupulously by KPTCL. The board is also appraised of the need to avail their services in the area of respective ESCOMs where they are working even after their appointment. Then the board recalled the discussions had in the earlier meeting in this regard. Contract assistant juniors have been discharging their duties satisfactorily, deserve to be considered for permanent appointment. Board also examined possibility of ESCOMs appointing them directly. Since the issue of options of existing employees not settled, it was felt desirable to appoint them by KPTCL and depute them to ESCOMs. After detailed deliberation, board resolved to appoint contract assistant engineers and contract junior engineers, appoint them as an employment notification.
It's just a fresh appointment. Just a fresh appointment,
Absolutely.
no pay protection, no counting of service, no seniority,
Made clear.
nothing of that.
So the mere fact that they did serve and they were continued, there was a possibility that the board could have said that out of 1,000, we'll take only 500. But they decided that how many ever were there, they were working, we'll appoint them now. And this position was made clear is the submission that I'm making. Right? It's not that there was any ambiguity.
Was the process carried out when they were regularly appointed?
There was,
What is required under the rules?
yes, all those were followed. They were all followed. But the thing is, there was also, my lord, at some stage, because of budget and other restrictions, the government had said, don't increase your employment. But at the same time, my lord, having regard to this was again a question of transition, my lord, because 99, the new electricity, Karnataka Electricity Reforms Act was introduced. It took about 1 year for the board, entirely the board, which was doing distribution and transmission work. It became KPTCL, that is Karnataka Power Transmission Corporation. So that came in the place of the board, which was doing all the functions, transmission and distribution for the whole state. Then, the second phase, the government decided that the distribution must be moved out. The transmission corporation will do only transmission of power from generating points to consumption points. That is main distribution areas. And for entire state was divided into different ESCOMs, electric supply company, Bangalore, Mysore, like that, or area-wise, geographically. And those separate companies were set up. And the object, my lord, was the World Bank, my lord, is the one which actually pushed for reforms in the electricity sector. Because one of the problems was that the total generation capacity in the country was not going up. And it was hampering the growth of the country in all fields. Also, it was causing a lot of difficulties, my lord, for the villagers because there was inadequate supply. There was no power available. And we hear of not 8 hours, 9 hours power cuts in major cities was something very common in the early 80s and even before that. So, my lord, the World Bank came in and said, we are going to fund something, but you people have to reform the law and bring in an independent regulator. If government does everything, then there will be so many issues that will be, what shall you say, covered up for political and other reasons. So, they said, you must have an independent regulator. So, that's how, my lord, the 1978 Act, the Central Act came. And since it's a concurrent subject, the State Act came in 1999. And the State Act, my lord, provided for setting up of an electricity company as KPTCL under the Companies Act, which will take over the functions of the board under the Supply Act of 1948. After that happened, my lord, then the next phase of unbundling, as they call it, is distribution to be moved out. One of the reasons given by the World Bank, which also the state government accepted, was that if you have different smaller entities, it is easier to get entrepreneurs to come and invest in these companies. If you partially privatize this, supposing you sell 25% shares, like in Bombay, Ahmedabad, the other areas, there are private companies which are operating the distribution systems. So like that, you may get people here also. In Karnataka, there's only one private distributor, not that's in Hukeri area, where a small society is a distribution agent for about 500, about 5,000, 6,000 suppliers are being given by that company. That's the only one which is a distribution licensee other than state sector. So when they did this, the problem arose, all the employees in the sector, they said the act provided as to they will all become employees of KPTCL. And they said, I don't want to go to Hubli, I don't want to go to Gulbarga, I want to remain. Then there was a challenge to that. Then there was a collective bargaining. This Honorable Court not interfered. And His Lordship Justice Dattu Lord sitting as a single judge in those cases, he said, the Act provides certain safeguards. You can't go beyond it. So the only way in which you can persuade people, because there were two problems with that. One is if the employer decides, then seniority is going to get disrupted completely because now there are independent companies. So if I am number one as a chief engineer in one company and I'm posted to another company, somebody who, and a junior of mine goes there, he will become chief engineer there.
You know, that is his luck.
That's right. And those.
But options are given.
Options, though, therefore, my lord, there was a collective bargaining in the second round. And the entities, my lord, gave an option to everybody to say, now we are giving you an option, we are giving you a time frame within which you please decide whether you want to remain in this. If you are in Bangalore, you have a choice of being in KPTCL or in BESCOM. If you are posted even as a KEB employee, my lord, if he was working in Mysore, then he was given a choice. Mysore is Chamundeshwari Electric Supply. So you can be on the roles of Chamundeshwari because in KPTCL, we don't need so many engineers. We are only doing transmission. So once they opted for it, then it was made clear to them that whatever be the inter-se seniority that is going to arise on account of these options given, everybody is bound by them. You can't then complain that I was number 3 in the state list. Now I have become number 5 here or 3 here or 2 here. So that process took some time. That is why, my lord, they noticed that also, that this allocation became difficult. But the thing is, Manoj, so far as this point is concerned, I think everybody accepted the situation that they were in that sense temporary. And only when they appointed permanently, that's the time, Manoj, when they would get any kind of power. Manoj, the Government of India notification, Manoj, deals with this background. Your lordships are familiar with it, Manoj, just to draw attention to why it became necessary. Annexure G, Manoj. Annexure F is a government notification at 171. It gives, Manoj, some background as to why this pension scheme had to be introduced at 172, Manoj, the English version.
Because in the previous avatar, see, the intent is the service conditions would not be at variance with what they were enjoying earlier. That's the basic intent. So service conditions would remain the same, all those pension, but also that is not really applicable here. But that it appears to be the intent also whenever they were being sent to these these companies.
There's a specific provision in the Act, Manoj, that their service conditions, whichever company they go to, will not be adverse to what they were enjoying in their current employment. Otherwise, the Act would probably have been challenged on the ground that it is unconstitutional. You are taking away some employees' rights. So they said that is protected. Even in company amalgamations, Manoj, we have a clause like that in the scheme, where they say that consequent upon this merger or demerger, none of the employees' terms and conditions are going to be affected, irrespective of which company they are going to be working under. So that protection was there in the Act also. That is the one which the Honorable Court relied upon to say that if it is going to affect him, you can't do it. You can't do it forcibly. So then the court said, all right, you give them a choice and let them take an informed decision. And seniority list, everything is available. So then they take the call. So this only gives, Milord, a brief idea of the economic reasons for the new pension scheme. Your lordships may only see, Milord, that page 173, it starts at 172. Bottom of page 172. The system would be mandatory for all new recruits to the central government service from 1/1/2004, except armed services, etc. Monthly contribution would be 10% of the salary and DA to be paid to the employee, matched by the central government. However, there will be no contribution from government in respect of individuals who are not government employees. The contributions and investment returns would be deposited in a non-withdrawable pension Tier 1 account. The existing provisions as defined in the benefit pension and GPF would not be available to the new recruits in the central government service. In addition to the above pension account, each engineer may also have a voluntary withdrawable, that is not GPF, etc. Then third is regarding retirement, 60 years of age. Then architecture at the bottom, page 173. It will have a central record-keeping accounting infrastructure, several pension fund managers to offer 3 categories of schemes. Then participating entities will give out easily understood information, past performance, etc. So this was the background, which not state government accepted. Next page 174. In the operative portion, Milord, at 175, they take note, Milord, of the reasons as to why the central government has done this and what is the effect of it on the state's finances. At order portion number 1, the new defined contributory pension scheme shall be mandatory to all new recruits to the state government service joining on or after 1/4/2006. The monthly contribution shall be 10% of the basic pay, Milord, rest of it matching, etc. And more or less they have, copied, Milord, what the central government has done. How much of it to be invested, how it is to be invested, etc. Then your lordships have seen the appointment letter and the contract. Kindly then go to page 184. This is the document, Milord, which was challenged. This comes in 2007. This is the amendment, Milord, which the learned judge finds that it should have been gazetted. Yes. At page 184, KPTCL is pleased to accord approval for implementing the new defined contribution scheme 1/4/2006 for new entrants to KPTCL ESCOM service as follows. The new defined contributory pension scheme shall be mandatory to all new recruits to KPTCL joining service after 1/4/2006. Then the rest of it is repetition. This is because that was a state government and this is the corporation, that is a company which is adopting this. And the mechanism, my lord, is provided. Then, my lord, the representations, they start at page 213.
Here it is defined, defined contribution. In the previous avatar, it is defined benefits. No contribution, the benefits would be whatever the previous old scheme decides. So that was the difference.
Please,
What you contribute, you will get accordingly.
please.
Now, there it was not that. It is the government's obligation to pay this is what you will
Exactly.
get.
Correct.
Say 50% of the average pay of the 10 months.
done.
That's the calculation.
Correct. So the first of the representations, my lord, is annexure M at page 210. This is in 2014. So from 2007 to 14, 7 years, my lord, they fell in line, they contributed, there's no objection whatsoever. For the first time, my lord, they make this representation. First para, my lord, in annexure M, page 210. We were recruited as contract assistant engineers on 5th November 2003. Vide notification on consolidated pay. Our services were regularized on 30/4/2007. New contributory pension scheme imposed.
Not in 2006.
2006, my lord, it came.
Regularization.
Yeah, regularization after that, 30/4/2007. Seven. All of them is after 2007. Then, my lord, they say, it's been stated in the
We'll continue, Mr. Nagar.
Please, please, please.
It's in the other matter.
In fact, Lord, on 16/3/2007, Lord, the regularization has taken place, the board resolution. And Lord, on 30th of April 2007, they have been issued with the appointment order. Subsequent to that, Lord, in 5th of July 2007, Lord, they adopted the scheme, which is introduced applying the 1/4/2006 for the fresh recruits. Lord. We are already recruited prior to the
No, fresh recruits after 3/4/2007 were given the benefit of the old scheme. That's what you are.
5/7/2007 is the adoption by the corporation, Lords, the government order, which introduced the scheme, Lords, with effect from 1/4/2006. Lord, we were earlier to that only, Lord, our services came to be regularized and we were appointed prior to, Lord, 31/12/2003 and to the sanction, the substantive posts which were available at that point of time.
But we just see it. Ultimately, what is being argued is the.
But whichever is more beneficial is not the petitioners are more
That will be your
happy
argument.
if they are
That will be
given
your
old
argument.
pension scheme.
Yeah, just give the dates, ma'am. We'll give the dates.
Please.
Passover, we'll give the dates. Just give the dates, ma'am. Passover. They'll give the dates. Who is in item 2?
Please, madam, and for the appellant.
Yeah.
I have completed the office objection, madam. Can it be posted for plenary hearing? I complied,
How many are there?
only one is there.
What is that objection?
The office has asked us to file a copy of the affidavit, my lord. But we have filed the typed copy, then we have filed the copy of the
We
affidavit.
will have it, just give it in first week.
Interim order may be extended in our case.
Just say that, yeah, we have heard Mr. S.S. Naganan, senior counsel for the appellants in part to come up for further arguments on interim order, if any, to continue.
Yes.
In all the matters or
Yes,
only
ma'am. All matters.
wherever there is an interim order, that shall continue till the next date of hearing. Just say like this.
7th April.
We get it. Just give the dates, ma'am. Okay?
Please. Yeah.
To 7th April.
Nimm the 7th April.
Okay.
Madam,
7th April.
Madam, 7th April. You're in that one?